We're live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Okay, good morning, and welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono, and I'm joined today by Justice Mary Sullivan and Justice Peter Rubin, and we will be the panel hearing your case. Just two brief reminders before we begin, and that is the same rules that apply to oral argument in the courtroom, except for the fact that you can sit during a oral argument on Zoom, do apply. So in other words, my point is that you each have 15 minutes to make your argument, and there is no rebuttal in the appeals court. And second, and I don't want to jinx anything, but upon occasion, we have some technical difficulties during the course of the argument. If we do, we will be patient with you, and we hope that you'll be patient with us as well. So with that preamble, I'm going to call the first case, XL Recycling versus Freetown Select Board and others, 2020-0560. Attorney Pucci?
Good morning. May it please the court. My name is George Pucci, and I represent the Freetown Select Board. This is a case that involves the certiorari judicial review standard of review. And the main focus of our appeal is the Superior Court judge's inversion of the applicable standard of review, ignoring neighbors' complaints about the adverse effects of XL's operations on their neighborhood as the basis for the board's decision. By way of background, XL has a scrap metal and processing recycling business in Freetown. They obtained a junk dealer's license from the town of Freetown from the select board in 2015 originally. Then they built out the property and in connection with a Mass DEP air permit, which they finalized in 2016, they began sort of operations in 2016. Junk dealers' licenses are under the statute, Chapter 140, Section 54, and under the town bylaw. They're discretionary licenses under both the statute and the bylaw. The board may issue junk dealers' licenses, and under the statute, these licenses are also revocable at the pleasure of the board. The licenses run year to year from May 1 of one calendar year to May 1 of the following calendar year. So there's just a little bit of background in terms of relevance over the years and the Superior Court decisions at issue leading to the decision now on appeal.
If I may, by way of background, there are some references to in the record to a 2007 license, but I gather that that was just a misnomer, that those were intended to refer to the 2017 license. And I also gathered that we're dealing here with the application for the 2018 license. Is that correct?
Correct, Your Honor.
All right. Is the 2017 license in the record anywhere?
No, but the history concerning the 2017 license is reflected in the Superior Court decisions, I believe, including the one that's on appeal. Basically, may we take the hours of operation as undisputed, the 8 to 4 hours of operation? Well, Your Honor, that's an interesting point. Basically, that hours of operation restriction was on the 2017 renewal. That was appealed by XL and then affirmed by the Superior Court. The hours of operation restriction as properly within the board's discretion. However, Your Honor, that license expired. So actually, technically, there are no hours of operation restrictions on XL presently because there's no license in effect. Basically, the latest Superior Court decision ordered the issuance of the license, and that's now on appeal before you. But the hours of okay, so
but the 2017 license, the hours of operation when it was in force and effect were 8 to 4.
Yes, Your Honor.
Is that what we're supposed to take? Because I went to verify it and I couldn't find the license.
Yes, Your Honor, but it's not. That is reflected in the record, but it's not really at issue because And actually, this was a big part of the appeal that I wanted to focus in on in the latest Superior Court decision. Focusing on the hours of operation restriction is somewhat of a red herring. And that's of no disrespect to Your Honor asking the question. But when basically the Judge Yasayan, the Superior Court judge, he upheld the hours of operation restriction. Then when the license renewal came up in 2018, a different judge heard it for April of 2018 for renewal for 18 to 19.
Well, perhaps I can save you some of your time. I'm not looking at the legality. I'm not looking at the older case. It's just that there was a lot of evidence before your client. Well, there was some evidence before your client, which you appear to have argued in your brief, that Excel was operating outside the hours of operation. So I was just trying to nail down what those hours were.
No, and I'm glad you did, because I wanted to get to that in my argument this morning. In Judge Yasayan's latest opinion that's on appeal before the court, he focused on that. He focused on Select Board Member Pacheco's reference to a list that she prepared of hours of operation violations. However, what's important is, and this is what I'm talking about inversion of the standard of review. The judge was required to basically cast about to discover rational basis for the board's decision. And he was to determine whether there was no ground upon which a reasonable person could uphold the license denial. What he did instead was he inverted it. He cast about in the record to find some basis for overturning the board's decision.
I'm sorry, can I interrupt you? This strikes me as an important point, this casting about for a reason. Sometimes when we get no reasoning from a court or a board maybe, but certainly from a court, it just says denied. We do kind of cast about and try to figure out if there's support for it. Or there's a substantial evidence test sometimes, and we look around and see, well, was there some substantial evidence to support this? But in this case, we have two board members who have, not in a written document, but on the record, given among the reasons for their denial of the license. One of them gave this list, and the other one read a letter from a lawyer. You know the items I'm talking about. I guess what I'm trying to figure out is it true that we are supposed to, even if the reasons they gave were improper, cast about for a reason to uphold what they did? If those reasons were improper, who knows what they would have done had they been knocked out? Shouldn't we, if we find that there is evidence sufficient to support the denial, and I think there probably is, but obviously we haven't, I speak only for myself, shouldn't we be remanding the case rather than affirming it because there happens to be something in the record that would support it, even though we have no way of knowing what the actual select board would do if they couldn't use, and I don't know if they could or couldn't use, this list and this letter from the lawyer?
That would be a good approach. However, in this case, you don't need to cast about to find support for their decision. And that's my point about, it's a red herring, the issue about hours of operation violations, and also the letter from Mackey and Shea that Select Board Member Joes referred to. They referred to that, the list was referred to, and the Mackey letter was referred to only in terms of an overall review of the voluminous record that was before them. It was a minor part of the basis for the board's decision.
How do you know?
Well, because it's in the record.
I understand the record has lots of stuff, but how do you know they didn't discredit everything except the list and the letter? I don't know how you know what they were thinking about the rest of the record.
It came from their own mouths, Your Honor. Select Board Member Pacheco specifically talked about the neighbors' complaints. And she talked about the fact that there was continuing smoke. There is black smoke coming out of the facility, debris which continues to invade residents' homes and town roads, odors and pollutants. I smell it every time I go there, including on the night, the tour that Excel provided. noise from early morning until early evening with erratic explosions that are unexplainable. She stated this herself as the basis for her decision. Selectman Joes, despite his review of the Mackey and Shea letter, Selectman, and I have to point out, these are, volunteer members acting in good faith and really trying to put a good faith effort into reviewing everything before them. The Mackey and Shea letter, yes, he referred to on the record, but he was very clear. He acknowledged that the sound mitigation efforts made by Excel had improved noise somewhat, but that noise continued to be a problem, and that there also continued to be problems with air quality, oily odors, and vibration impacts on nearby residents. So despite the reference to the list of hours of operation restrictions, violations, and the Mackey and Shea letter, both board members were very clear on their rationale and what the basis was for their denial.
Do you agree that Excel did not have an opportunity to respond to either the list or the letter?
I would be happy to concede that issue for the sake of appeal, because they are red herring issues. You don't need a response to those.
You say they're red herring issues. I assume you don't mean that there is, I thought there was evidence aside from that list of out of hours operation. And I thought that you're not saying that that is permissible, right? Wouldn't that
No,
be
I'm not
valid?
saying it's
If I cast about in the record, am I not going to find evidence of out of hours operation that by itself would be sufficient to support denial?
Well, that's an interesting point. I'm conceding that Select Board Member Pacheco's basis was not the hours of operation violations. However, the case law is clear.
That's not a concession.
Well,
right? Your brother says it was, and that's why it's no good. So it's not really a concession to say.
Well, the case law is clear that she's allowed to, rely in part on her own experience, as a local board member. So that list was not improper. What I'm really saying.
What's your best case for the proposition that she can go out and personally observe? This is what I saw on the record, that she went out and personally observed for a series of days. She then questioned Excel at the hearing and had them commit that their hours of operation were only 8 to 4. And then on the second day, when they were not permitted to respond, she said, well, their hours aren't 8 to 4 because I went out there and I saw them doing the following things. What's your best case for the proposition that that's okay?
That the recent Cumberland Farms case from the appeals court that we cited, that the select board members can base it on their own personal observations. But again,
by the way, I'm sure she did it in all good faith, that she was being a conscientious citizen. She just may not have realized, what the rules were about doing that. I'm not casting any aspersions on her, but it's kind of an important issue.
I'm also insistent on bringing the focus back that the basis for Select Board Member Pacheco's denial was not violation of the hours of operation restriction. It was the adverse effects reported by the neighbors that I just read from her own words on the record, that she gave the basis for her decision.
Understood. What do you say to the judge's point that there is no noise or air quality bylaw or regulation in the town by which to measure that judgment, and that in the absence of that, compliance with DEP's requirements should suffice?
I'm saying that that's an inversion of the applicable standard of judicial review. There is no requirement for this licensing decision that the neighbors' complaints, their own personal observations of the adverse effects on the quiet enjoyment of their residences, needs to be corroborated any further than them testifying at the public hearing. It was for the two board members who heard this to judge the credibility of the neighbors' complaints, which I would respectfully suggest that, based on the record, are obviously credible. They obviously don't have anything better to do than to come and complain about Excel's operations. These are serious adverse effects that they reported to the board. And there was no...
Attorney Pucci, there was also evidence that some of those complaints were unsubstantiated when they're investigated by the local police. Isn't that right?
Thank you, Your Honor. That is absolutely incorrect. And that was another issue about the judge casting about to find a reason to overturn the decision. Those police reports that he referred to a specific period of time from March 2017 to December 2017. They had to do with residents complaining about Excel operating outside the restricted hours of operation. That was not the issue before the board.
No, wasn't there also an allegation about noise?
There were, and in fact, if you look at those police records, they actually confirm the issue about noise, because one of the businesses that the police went out and responded to that night was another business that it turned out that they were the one operating. That operator said that when Excel is operating, the building shakes, the ground vibrates. Just the other day before them coming there in 2017, there was an incident at Excel that sounded like an earthquake, according to him. So what my point is about it is, number one, the judge did not have the right to overturn the credibility of the neighbors' complaints about noise based on police incident reports. Number two, those police incident reports did not refute the overall complaints about noise and other issues that the residents experienced from that facility. They had to do with operating outside the hours of operation restrictions in the 2017 license. It was totally not an issue.
Okay, thank you for answering my question. I see your time is up. We've used a lot of your time answering our questions, and we appreciate that. Let me just check with the panel to see if they have anything else that they want you to clarify. And I see nothing. And so we'll take the rest of your arguments which are well explained from your brief, okay?
Thank you, Your Honor.
Thank you. All right, we're turning now to Attorney Markey.
Thank you very much, Your Honor. May it please the court, John Markey on behalf of the plaintiff in the underlying case and the appellee in this case, Excel Recycling. I want to go directly to what Justice Rubin made as a point. In this case, you have 12 pages in the transcript, pages 734 to 746, in which the select board members describe what the basis is for their decision. 9 of those 12 pages refer to information which was not in the record and presented during the hearing. That's 75% of the time they had to explain their decision was on things that were not included in the record. It is particularly troubling, Your Honors, in this case where there were multiple trips made by Excel to town hall in advance of the hearings to say, please provide me with any evidence you have so that we can provide a record to respond to these items. The reason they did that is exactly because of what Justice Vuono said, which was sometimes there were complaints made by neighbors. When we went to go to the police department or the fire department, we found out that, not surprisingly, some of the noise early in the morning or during the day was the result of neighboring businesses in an industrial park. This is an industrial park in an as-of-right use. I do not dispute that the neighbors would prefer if Excel and other industrial businesses didn't operate there and make noise. The reality is they bought residential homes that directly abut an industrial park for which
you're asking for a remand so that you have a chance to respond to this evidence?
Your Honor, I would respectfully suggest that Judge Hussain found the just result in this case. The court is aware of some of the history of 3 years of litigation, but the fact that the town hid evidence basically from our clients that they were going to rely upon. And the fact that
my question is whether what you're asking for, therefore, is a remand to address the evidence.
No, I think the remedy that the judge ordered, which is the issuance of a permit, was the right remedy.
How can that be the remedy for not having a right to respond to the material? I don't understand that.
Oh, I appreciate the question, Judge. Here is, I think the point in the larger context is an underlying one which the court may have another way to approach. as the court knows from the record, before my clients bought this property, they went to the building inspector to confirm it was as of right, and they went to the then sitting select board to get the required permits. For safety reasons and to ensure things, they bought, when they acquired, without restriction, a $25 junk dealer's permit, which is issued on an annual basis. And for the court to know under 14054, that junk dealer's permit is $25 and is normally, in normal circumstances, designed for someone who drives around with a scrap metal truck and goes to junkyards. That's what it's basically for. And the idea that a family would spend $10 million to build a facility after relying upon the town and $2 million to mitigate it, to reduce, should then be able to be shut down on the whim of a few neighbors who are complaining is not.
So you're not saying the town is stopped to issue the license, are you? That's not what the judge held below. Are you saying that?
I'm suggesting, Judge, if you read the footnote that I meant, and one of the other arguments that was a potential reason to uphold the court was this license under 14054 and under the Goldies and LaPointe case should only have been rejected by a town if there were underlying concerns about criminal activity by the applicant as an individual.
You know, that argument's only made in a footnote in the brief, right?
I appreciate that, Judge. And
was that issue
reason
raised
that I
before,
did
was that issue raised before the motion, Judge?
Not at the time of this motion. It had been raised
Okay.
in the original litigation. It was
Then
raised
I
in the
think
2018 case.
I think it might be more helpful because there's a lot of ground to cover. You're welcome to argue anything you want, but
No, I'm focusing on trying to answer the Mr. Justice Rubin's question regarding what's the appropriate remedy. And I think that that would give grounds to say, really, in these particular circumstances, we find, because it is there, and it was dropped in a footnote both at the lower level, that the court could have ruled on the basis of the fact that this type of a license, a $25 license, to make sure there's no criminal activity, and where the statute is designed to avoid criminal activity, shouldn't be used as a sword by a few neighbors who are upset about a business that's in compliance with all of the state standards. That's really a misuse of this annual license. That's the position that we had taken, but I appreciate what the court has stated. So I
have a couple of kind of precise factual questions.
Certainly.
One is, what much was made by the neighbors of a explosion which they say occurred on November 1st, and one neighbor claims to have seen the smoke rise from the smokestack. I looked at the record. I didn't see a police report from November 1. Is that correct, that we don't have any contemporaneous police report from November 1?
That is correct, Judge. And in normal circumstances, we would not call the police. If a neighbor had called the police and they had come, we would have responded and explained. But if we wouldn't know that they were going to be complaining about a particular day. But to my knowledge, there is no police report from November 1 of 18.
Okay, so the police reports that say we weren't able to substantiate this deal with a different period of time.
Exactly. And I don't know that Mr. Bucci's dates are exactly right, but the concept is correct. There was a period of time where neighbors made complaints to the police and the fire department. When we went back and got the police reports from those times, and I believe pages 611 to 621 of the record have those police reports, and largely they evidence the fact that either one of two things happened. It was noise made by a neighboring business, no noise at all after hours, or it was noise that was typical for an industrial area, which again, I don't dispute that the neighbor. I'm sorry, Judge.
So next question, since there seems to be some disputes about what has happened when or how loud the noise is, are there any surveillance cameras on this property at all?
There are for people entering and exiting, but I'm not certain that that's going to resolve the issues there, number one. And I think number two, noise is not necessarily something that would have been picked up by a camera to know exactly the sound. The best evidence, Your Honor, Your Justice Sullivan, in the record is that the Mass DEP set up a very rigorous and specific noise testing program. Epsilon Associates went to 3 neighboring houses and to the railroad line that abuts the back of the property and set up and asked them, turn this piece of machinery on, turn that piece of machinery on, turn them all on.
I'm
And
sorry,
found that all-
if you are saying that that as a matter of law, the select board is somehow preempted from imposing noise requirements above those of the state, I understand that as an argument, although I don't think it's the argument you make. I guess at the end of the day, and I don't know that I think this is a good thing, but it seems like as a matter of administrative law, the board is allowed to decide what evidence is credible and not. And there are, to begin with, there are complaints in the record from neighbors who are not the ones who called the police and are mentioned in the police reports. Beyond that, their credibility of all of the witnesses, including the police reporting ones, is for the, I think, for the select board. Do you have anything that suggests that the select board or a court on review has to find a police report more credible than eyewitness testimony?
Definitely not, Your Honor. But the point is simply what the court stated in its original question. It appears that the vast majority of their time as a select board was carefully designed to not present us with evidence that we were going to have to rebut, and then to use that at the last minute against us. So that is not what I mean.
No,
when
I
we talk
understand
about due
that.
process,
I understand it's a different, they're two different arguments, so yeah.
I appreciate the fact
We
that
understand that argument, but what do you say to the judge's point that if the select board, if the select board is going to set a higher noise standard than the DEP sets, or a different noise standard, doesn't necessarily mean higher. It could be just these loud intermittent noises are intolerable. Attorney Pucci says they can do that under Cumberland Farms. The judge said, no, they have to have a bylaw or regulation. What do you say, and what's your best case?
I'm going to defer to Judge Hussain on my best case, but I can talk in regard to this, Your Honor, that the specific bylaw in Freetown says if you want to restrict junk licenses, you can make more, the state law allows them to create more restrictive regulations, which they didn't do. As the court has referenced, if they want to make more restrictive regulations, whether it's the Conservation Commission on distance between water and sewer, just as the federal government creates a platform upon which the state can give extra constitutional rights, in this context, I will concede that the state creates a base foundation at the DEP, which we've met and satisfied by all of their professionals and all of our professionals. If the town had created a higher level and given businesses who put their houses and their lives on the line by making a $10 million investment when they're invited to town, then got notice, like, we have this standard, you're now going to have to retest yourself at this standard, that would be due process to someone who's made this kind of a life investment. But to suggest that, well, we're going to use the state standard and we're not really going to rely upon all the experts on all sides, but some neighbors don't like this, is not fundamentally fair under due process. I would respectfully
Can I ask
suggest
about things other than noise? That I see your point, particularly where there is a state standard. But let's say neighbors come in and complain, debris lands on my property, or they operate out of hours, or it smells really bad. Can those be, I mean, my understanding of this area of law was that there was some discretion. Those are rational reasons for maybe denying someone a license, and you can be asked to respond to that and so on. But that if that's what it's been like with the place operating, that they don't have to allow a license going forward. Is that incorrect, though?
No, I think, Your Honor, Justice Rubin, that your statement of the rules is correct. I think the concern that exists here is that we do have a long history with Mr. Pucci in this case. It is true that in 16 and 17, when this operated, some of the facility did not have covers and canvases on conveyor belts. And so there was what I would refer to as fluff when they were doing some shredding of material that would go off premises. those complaints, although not completely eliminated, and I'm not going to tell the court that it never ever happened, but I'm unaware that that's a major concern anymore. But it clearly was early, and it was addressed just like all the other DEP issues were addressed. When you create a new industrial facility that has a permit with conditions, we were responsive to those things. So I do think the things you reference could be factors that would be considered, but I think they all have to be looking at in the context of the entirety of these proceedings when we were in front of this group of select board members. And I think it's noteworthy as well as to what was going on here. The third member of the select board who did not sit because of a conflict is a direct abutter who ran for office as an opponent to Excel Recycling. Although he didn't participate publicly in these hearings, there is the hint that certainly they knew he would be happier if this result came about that they achieved by not providing us with the evidence in our multiple trips to town hall in advance of the hearing. So I don't think that I have much more to say. I think the court really read the record very carefully and has asked some excellent pointed questions of both of us, but I'm happy to answer any other questions you may have.
Let me check with the panel. I don't see any of the questions from either one of them. I don't have any questions either. I want to thank you both very much for your arguments today and for your briefs. We'll take the case under advisement and get an answer back to you as soon as possible. And it's still January, so I think it's still appropriate if on behalf of the panel, we wish you both a very safe and a very healthy new year.
Same to you. Thank you.
We are live.
Okay, thank you very much and good morning and welcome to today's remote sitting of the appeals court. My name is Ariane Vuono. I'm joined today by Justice Mary Sullivan and Justice Peter Rubin, and we are the panel that will be hearing your case. You are the only person arguing today. You have 15 minutes to present your argument. I don't even need to give you any more reminders since you're the only one appearing, just to let you know that if perchance we had any technical difficulties during today's argument, we will be patient with you to resolve them, and we hope that you'll be patient with us. So the name of this case is George FERREIRA versus Christine Daniels. The number is 2020-0531. And Attorney Chinman, look forward to your argument.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Michael Chinman, representing Christine Daniels. The issue raised in this appeal is simple. My brief is short, and I won't belabor the point made. I believe the law is clear that the probate court judge erred in determining that there was no obligation by Mr. FERREIRA to make an equal contribution towards college costs because the agreement provided that the parties would make best efforts to do so. Stabile v. Stabile is very clear that best efforts is an enforceable provision in a divorce order, and it was a provision in this divorce order. The transcript makes clear that the probate court judge immediately went off the rails. I think it's page 5 of the transcript on line 7, I think it is. The judge was unfamiliar with what the divorce agreement provided about college costs. Ms. Daniels and excuse me, maybe the judge also wasn't that the case of Stabile versus Stabile was not brought to his attention. Let's put it that way. Well, it's a fair point, Judge, that the parties were pro se on the contempt motion. That's a fair point. Mm-hmm. And I think you could make a point about penny wise and pound foolish. But there's no doubt that the judge was still obligated to follow this court's rulings. Stabile v. Stabile was good law at that time, and it still is. In fact, this court cited Stabile v. Stabile less than 2 weeks ago in the case Pedro v. Pedro. Yeah, I think the lack of attorney on either side for the parties contributed to the situation we're in today, but that does not excuse the judge from immediately going off the rails. When he was alerted to, on line 10, he quoted the provision, and then on line 11, he expresses doubt that it was enforceable. The holding in Stabile v. Stabile makes it very clear that best efforts is entirely an enforceable provision. And the parties relied on that. And I made an error in my brief. I said that 5 years after Stabile v. Stabile, the parties represented by counsel at that time incorporated the best efforts language into their divorce agreement. That was a mistake. It was actually less than 4 years after Stabile v. Stabile. So it's not even before this court.
Counsel?
Yes.
What do you say about the differences in language between this order and the order in Stabile? Stabile had not only best efforts, but a clear command to contribute $10,000 annually by December 31st, language which I take it was not in this agreement. Is that a material distinction?
Well, number one, this court in Stabile said that take away the $10,000 language and you still have something enforceable on best efforts. And number two, the $10,000 is a benchmark. It measures compliance with whether the person commanded to do that is doing it. And we have a benchmark in this case also because the parties agreed to contribute equally to reasonable college costs. Now, it's not a dollar figure. I'm sorry?
Consistent with the parties' respective financial circumstances, right? That was the qualification.
Correct. But that goes to how much. It doesn't go to enforceability at all. And the probate court judge here never reached how much, never got to the point of evaluating what each party was able to contribute. He terminated the inquiry at there is no enforceable agreement here. And Stabile clearly contradicts that. There is an enforceable agreement. So Stabile, the point I was trying to make is that the issue of whether Stabile should remain good law is not even raised in this appeal. The appellee did not file a brief, made no argument that Stabile is no longer good, and there is no party who was aggrieved by application of Stabile to raise that issue. The party aggrieved is Ms. Daniels, who was aggrieved by the failure to enforce the holding in Stabile. So there's no doubt Stabile was good law a year ago when the probate court judge ruled on the contempt complaint, and that was error.
So what is the remedy? If we were to agree with you that the best efforts language required some contribution and that the issue becomes how much, does this require a remand for how much?
Absolutely. It's not before this court whether Mr. FERREIRA has the ability to pay or how much he should pay or whether he made best efforts. None of that is before this court. The only thing before this court is whether it was an enforceable order in the divorce order. And Stabile says it was, and so it must be remanded back for further proceedings to the probate court.
As to both best efforts and amount?
Correct.
Although presumably best efforts, if the judge finds that the command to use best efforts was not violated, the judge would not get to amount, right?
I suppose that's theoretically true, Your Honor. It's hard to see.
Not theoretically true, it's actually true, right?
Well, I meant it's not actually true in this case. In this case, Mr. FERREIRA, he saved less than $5 a week.
I don't know anything about his finances. It says consistent with his financial position. You may be right that if he had used his best efforts, whatever that means, he would have had more dollars, right?
I'm not arguing for a second that the probate court judge could find that, but that just, again, goes to amount and not enforceability.
Mm-hmm.
Right. Well, it's a fairly clear-cut question that's been briefed. I for one don't have any further questions. Do you have any? Do the rest of the panel have any questions for Attorney Tinman? No. All right, well then, thank you very much. Thank you for your argument. We'll get an answer back to you as soon as we possibly can. And meanwhile, it's still January, so the panel wants to wish you a very safe and very healthy new year.
Thank you, Your Honor. I wish that to you all.
We are live.
Thank you very much. And good morning. My name is Ariane Vuono. I'm joined today by Justice Mary Sullivan and Justice Peter Rubin, and we will be the panel hearing your case today. I'm going to call the case first, and then I have just a couple of reminders for you. The case is Chamberlain versus BYBLOS Investments International and others, 2019-1819. Just want to remind you that you each have 15 minutes to present your argument, and there is no rebuttal in the appeals court. And that in the case we have any technical difficulties, and we hope that we don't, we promise that we will be patient with you, and in return, we expect you to be patient with us. Usually they resolve fairly quickly. With that said, I'd like to go ahead and ask Attorney Chafin to begin your argument.
Thank you, Your Honor. Members of the panel, may it please the court. My name is David Chafin. I represent the defendant appellants. They are the trustees of the 549-551 Boylston Street Condominium Trust, the trust itself, and BYBLOS Investments International, LLC. 549 to 551 Boylston Street is a 5-unit condominium building. The 549-551 Condominium Street Trust is the organization of unit owners for that condominium. BYBLOS Investments owns condominium unit 101. Plaintiffs' appellees are the trustees of the trust that owns unit 201 of the condominium. Defendants appeal from a single paragraph out of 16 of the trial court's October 12, 2019 amended final judgment. There, the trial court declared that an exhaust agreement covered areas within a condominium unit, unit 101, and common areas, and that the proceeds from that agreement therefore had to be split 50-50 between the unit or the unit owner and the condominium trust. This was error. Defendants therefore asked that the court reverse paragraph 7 of the amended judgment and order the entry of judgment that the proceeds of the exhaust vent agreement belong to unit 101. The material facts are not numerous, nor are they controverted. They are as follows. In 1998, a company called Molded Antennas for Telecommunications owned the building at issue. On August 20, 1998, Molded converted the building into the condominiums at issue by recording a master deed under Chapter 183 of the General Laws. I'll come back to some of the terms of the master deed in a moment. Unit 101 of the condominium, owned by BYBLOS, comprises the basement, first floor, mezzanine, and back half of the second floor of the building. That is Unit 101's mechanical room. It was the subject of some prior litigation, including a case that reached this court. The second floor rear, again, is the mechanical room. The second floor front is Unit 201, owned by defendants. In January 1999, after the condominium was created, the owner, Molded, entered into, as Molded, not as the trust that was then the unit owners organization, entered into the exhaust agreement. Under this agreement, the building next door obtained the right to use the exhaust vent system of 549-551 Boylston Street to vent the exhaust from the restaurant in the next door building.
Do they share a common wall? How does that work?
I believe it is a common wall, Your Honor. There is no space between the two buildings.
I see, okay.
The exhaust vent consisted of elements, ductwork, and the like in the mechanical room of Unit 101, the rear mechanical room up on the second floor, as well as ductwork that ran up the back of the building and up to the roof. The system, as Judge Wilkins found, could and cannot function without both parts. the part within Unit 101 and the part outside. The exhaust system, the vent system, has been used by Unit 101 tenants at various times, not always, as well as the building next door. It has never been used by any other unit in the building, 549 to 550.
I don't understand the part that's outside.
Yes, Your Honor.
Do you agree that's common area?
Is that common area?
Yeah.
I don't believe so, Your Honor. No.
It's outside.
It is outside. Agreed, Your Honor. So
Well, why isn't it common area?
for a number of reasons. First of all, if you read section 4E of the master deed, it provides that conduits, pipes, et cetera, that are within a unit are a part of the unit. Now, given Judge Wilkins' finding that this was a unitary system, right? It wasn't, components. I don't believe that it's fair. He has read into that language that a conduit has to be exclusively within the unit. We believe this is one unitary system, and the language of 4E doesn't permit dicing it up based on inside and outside.
Well, except you're saying that it's the inside, the unitness of it that makes it unitary. You could say it the exact opposite way, right? Which is, this is something that's outside the building. Part of it extends into the building, but it can't be both, so it must all be common area. I'm not saying that's right. I'm just saying I don't, you know what I mean?
Well, it's not the insidedness that makes it unitary, Your Honor. It's the functionality. It can only work, as Judge Wilkins found, together and as one unitary whole. And since part of it is—
Why isn't that exactly why this equitable 50-50 split is completely reasonable?
Well, again, for several reasons, Your Honor. So we rely on section 4E, for example, of the language. The other reason is none of the other units in this building can utilize this exhaust vent for a number of reasons, both physical and because of restrictions in the master deed. This is something that relates only to Unit 101, and that would mean the maintenance portions of it as well. I think the judge has inserted the word exclusively into the language of 4E. At worst, for our, and there is an exception, as you know, for a conduit that services other units. That doesn't apply here because this system doesn't apply at all. I think the argument at worst, Your Honor, if you parse the entire master deed, you've got at worst some ambiguity with respect to these components in particular. So what do we look at to determine what is meant with respect to these components in particular? So we look at 4, which defines the units, but it doesn't say, the language itself isn't clear because it refers to Exhibit A of the master deed, which is just the property description. It isn't a listing, it isn't plans, it's Exhibit A, it's a property description. And it says here are the components of the unit. And then the closest thing in 4 to what we're talking about here would be the description of conduits. Admittedly, it's not perfect here. So what else do we find in the master deed that is helpful on intention? And what else do we find that the declarant did through this master deed? If you look at 5, the discussion of HVAC systems in this building, it talks about each unit has its own heat pump, and the parts of that heat pump, even exterior to the unit, are part of that unit. Now, admittedly, this master deed didn't reference this exhaust stack specifically, but the intention with respect to the highly analogous heat pumps and the exterior conduits from the heat pumps, to have them be part of the unit, I think bears on what was intended with respect to the exhaust.
Do you agree that this legal question, is this a common area, the outside part, or is it part of the unit? That's an essential question to this case, and that if it's an outside area, this is an affirmance, a common area, it's an affirmance, and if it's an inside area, it's a reversal?
I think if it's a common area, it's affirmance on the first part, that remedy issue aside, right? Yes, the common area would be, of course, step one that plaintiffs need in order to get what Judge Wilkins has done affirmed, agreed. But again, is it common area? The other reason it isn't common area is if you look at 183A, Section 1, which defines common areas. This exhaust system is nothing like a common area. It isn't common. It doesn't serve any of the other units in this building. It serves exclusively 101. They're put there for that purpose. It isn't like the hallways. It isn't like the elevator. It isn't like the stairs.
Does that matter if it's outside the building and we conclude that outside the building are common areas?
Some of the language in 5 refers to on the building. But if you look at every reference to what's a common area in this master deed, you will see that it is accompanied with the word common. And what does that mean? It means all the units, not just one unit. It's common use, common functionality.
Is there anything in the record about things like satellite dishes that may have been installed on the roof to serve one or another unit, or cables, or anything like that?
No, but was looking for an analogy. Exactly. If Unit 101 had put a satellite dish up on the unit, would they all have the right to use it?
Well, that's not a question of right to use it. I think the question would be, would you need permission from the trustees to do it? Right? Because is the roof or the side of the building belong to the trustees? You can't install something on it.
Well, maybe install now, but this was originally there as part of the building, this exhaust system.
The court also did say, in terms of serving, and I'll ask your brother more about this, said that inventing the exhaust, it serves all of the units. And I guess I'd say something like this. If you capped this thing at the wall and the exhaust kept coming over from next door, it would fill the entire building with exhaust, right? So in that sense, doesn't the venting part of it serve all of the units?
I'm sorry, I don't follow you, Honor.
The exhaust comes into the system from next door.
Yes.
And is then vented. It utilizes in part the part inside the apartment, and then it goes outside the apartment up through the stack. If you closed off the stack, let's say you disconnected it at the wall and capped it, and the outside part were gone altogether and capped.
Yes.
The wall belongs to the condo and they cap it. Wouldn't the building fill up with exhaust from next door with no way to vent it?
I don't
and
believe
therefore, mightn't the vent itself actually serve all of the units of the building by ensuring that exhaust from next door is vented rather than polluting all of the apartments in the building?
I don't believe, Your Honor, that the vent from next door actually enters the building. That I believe it attaches to the vent system on the exterior of the building. I could be.
What is the role of
is.
the inside? I don't understand then what the inside has to do with it at all.
So it's an entire. Well, we have the finding by Judge Wilkins, and that was.
Yeah.
But it's the entire exhaust vent system. All I can think about analogously is the vent system for a septic system, having just gone through that nightmare. But anyway, it's an entire unitary system. I believe it attaches outside.
Do you think that if it were disconnected, the whole outside were disconnected from the unit, it would still work? Venting the next door neighbors.
It would. I believe it would still work, but it would vent the exhaust at a much lower level. The idea is to get it up high, obviously. Yeah. So,
no, but the outside part has the stack up high, right? Or it's blowers and things inside.
Yeah, there were blowers keeping the air moving. Right. So.
At the risk of asking the obvious, do you agree that the exterior wall is a common area?
Yes, Your Honor. Okay. And it's attached to the wall. Agreed. But again, this doesn't serve. I know I'm beating a dead horse a little bit here. This isn't this vent system is not a common element, and it is as the closest language in this master deed to this system is the conduit within a unit, and this is partially within a unit, or you look analogously to the HVAC, or you look to what Molded intended at the time. Molded signed this agreement. It was the declarant of the trust. Certainly that it signed this agreement, kept the proceeds, believed it could enter into this agreement, what it intended with respect to this exhaust vent system.
It called itself landlord.
It did, Your Honor, but the
Meaning, how do you think, what does that mean? Does that mean if they did it as the owner of Unit 101, is it a tenancy? The use of your venting system?
Well, clearly they believe that. I mean, they believe they were renting something they could rent as Molded, not as condominium trust. It was then they rented it to the next door neighbor. They believed they could do that. I think that's telling. And if this exhaust vent system were common area, the trustees could force the tenant in 101 to rent it, right? Because it would be a common area. And it's just, it doesn't operate that way.
Well, they might not be able to force them to rent the part that's inside the apartment. I find this very complicated.
Well, but I think, yeah, 3 seconds, I'm sorry, but it's a unitary system, so I believe they could. So that's what Judge Wilkins found.
In other words, just to be clear, I'm sorry to ask you this at the end, because otherwise the venting system doesn't work. In other words, it needs the parts that are inside Unit 101 in order to function. Right?
That is the finding. I'm sorry I didn't address the second argument.
No, that's clear. I just wanted to thank you very much. I'm going to see if the panel has any more questions, although your time has expired. Sometimes we have some extra questions. I see none. Thank you very much. I'll return now to
thank you very much.
To Attorney Levine.
Good morning, Justices. Can everybody hear me?
Yes.
Thank you. Good morning, and may it please the court. Alex Levine for the plaintiff appellees, Walter Chamberlain and Yin Kao-ho as co-trustees of the Walter Chamberlain Revocable Trust, which I will refer to as the Chamberlain trustees. The trial court found the exhaust vent to be a common area element in accordance with Section 4 and Section 5 of the Master Deed. Section 4 defines unit property, which does not list the exhaust vent, and Section 5 lists the common area property, which does not explicitly reference the exhaust vent, but the trial court most reasonably allocated this exhaust vent to subsection F of Section 5, which classifies common area elements as, quote, all other apparatus and other common equipment wherever located in, on, or around the building and not located within the borders of a unit. We are at the appellate level because these condominium documents are not clear about the exhaust vent, but a logical reading of Section 5F does reasonably conclude that this exhaust vent fits into that category.
Does it have to serve more than one unit to be a common area?
Sometimes, but not necessarily. The condominium statute is an enabling statute and enables developers to draft whatever they like in the master deed and the declaration of trust. In this Section 5F, a common area element doesn't necessarily have to serve multiple units. And this just plainly states that if it's located in, on, or around the building, so it's wherever it's located, and not located within the borders of a unit. And in this particular,
do you know anything about how, is it in the record, anything, I asked your brother this, about how, for example, satellite dishes, cable wires, anything like that on the outside of the building that then service a single apartment are treated?
I did not find anything on the record. As a general rule, in the context of condominiums, it is not necessarily dispositive. Again, you can find condominium documents that say a wide variety of topics, specifically for satellite dishes, to address your question. That is most commonly dealt with exclusive use easements, as in this dish is unit property, this dish is on the common area roof of the condominium, and the association will allow you to maintain that. Satellite dishes are actually governed by the First Amendment, So there is some right to have that. However, you are on the common area roof and the association will grant you an exclusive use easement, which if it's not specifically referenced in the condominium documents, thereby already being granted, a separate easement document would be recorded in the registry of
And there is nothing in these documents about any type of outside the building mechanism or anything being allowed by easement granted in any of these documents.
That is correct. There are exclusive use easement grants that are listed in the master deed specifically for Unit 101. That does not include the exhaust vent.
What does it include?
I believe it's there's an exclusive use easement for the front of the building to maintain areas within the front of the building. And I argue to this panel that is dispositive because there are exclusive use easement grants granted to Unit 101, and it does not reference the exhaust vent. If the intent was for this to be solely associated with the unit, that exclusive use easement would have to appear, and that does not exist. And in particular, this vent either goes through a common area partition wall to a neighboring building and or links around the exterior of the building. Only the association has the ability to grant a neighboring building a right to either enter through a common area wall or to change the exterior appearance that's governed under the Architectural Integrity Clause to connect to an exhaust system that is attached to the exterior common area siding of the building. So
Do we know if this attachment existed prior to this being converted to condos?
I am not aware of that, Your Honor. I am not aware of that. And it's quite possible that the intent all along, which is not entirely clear, but can be seen from the condominium documents and the exhaust agreement, was the intent all along was to have the exterior exhaust vent structure maintained as a common area element, possibly for the exact purpose of being able to use it for one building or the other. The association receiving the rental proceeds. If a restaurant
there's a restaurant in the building next door?
That's correct. I believe it is a Wendy's restaurant.
And has there been a restaurant in Unit 101?
I don't believe so. There was a short window of a few years, I believe, before Unit 101 was sold to its current owner, which is now maintained as a dentist's office. There is on the record that at some point the exhaust system was used for 101. However, it was not dramatically elaborated on the record.
And
what about, excuse me, go ahead.
No, please.
No, I was going to ask about repairs. What about the cost of repairs then? In other words, what's your position with respect to that? Has this been maintained? Have there been repairs made? Do we know anything about that?
That's an excellent question. I was not the trial lawyer, so I only can kind of go what is based on the record, and from the record.
That's all we ask.
Yeah, from the record, the only thing I can conclude is that the actual lease agreement for the exhaust vent does assign and discuss maintenance responsibilities for the Wendy's, as in the Wendy's restaurant next door would have the right to access the condominium's common area roof, which is where part of the structure is located, in order to conduct maintenance.
We'll look at the lease agreement, but let me ask you this. If in fact this lease was signed by a unit owner, which it seems to have been, is it valid?
That's an interesting question. I believe this is a classic example of developers moving slightly too quickly, and what occurs in the condominium context shortly after the condominium is declared, and most of the units are sold to one entity. Sometimes it is treated like a landlord owns the building. I would purport that the quote unquote landlord, the signatory, is the signatory to the exhaust agreement, although signing in a different capacity, is also one of the original trustees of the condominium trust. It's quite possible the intent all along was to be binding upon the condominium trust, It's very clear from the assignment of rights that only the condominium trust and the association would have the ability to assign these rights to a neighboring building.
Is the lease time limited?
I believe it's automatically renewing.
So there is only one agreement signed one time that has been automatically renewing.
There was an amended agreement. I believe there was an amended agreement on the record that does not change the material terms.
Signed by MAT while it was still the owner of 101? Or by the BYBLOS Trust? Or whatever they are.
I don't want to waste the court's time, but since I'm doing this from
I can keep it up.
no, I actually think it's 148 of the appendix. I'm moving a little quickly, so 149 I believe is the signature page.
Yeah.
Executed by the LLC, 535 to 545 Boylston Street Properties LLC. So that's the neighbor. That's the neighbor. BYBLOS Investments International LLC, unit owner of Unit 101. However, and again, I make the same.
What year was that?
2009.
And do we know how much rent are they paying now? Does it escalate by itself, or how does that work? Rent, or whatever you want to call this fee, whatever it is.
I am not sure what the rent is.
Okay.
And part of what I'm asking the relief for is if this panel either affirms the judgment or concludes that all the proceeds are owed to the condominium trust to hold an assessment of damages hearing. I'm sure it's on the record somewhere in terms of the lease of what it is, but the actual dollars and cents calculation, I do not believe has been firmly established at this time.
Do you agree with your, now that you've read the responsive brief, that without a cross appeal, we can't give you the additional relief you asked?
It is undisputed. There was no cross appeal, so that's undisputed. But I do suggest that this panel does have the authority to enter the relief I requested based on a de novo review and also an appeals court case.
Unless I missed something, without a cross appeal, we can't award more than you've got half.
So an appeals court case, 1979, O'Connor versus City Manager of Medford.
Yes.
7 Mass App CT 615, page 618, does enable this court to have discretionary authority. And it's up to this court of whether it wishes to exercise that or not. But I do advocate. Forgive me, Your Honor.
No, please.
I do advocate.
I do have one question. Let's say there's a grease fire in this exhaust, which damages both Unit 101 and other units, and compromises the structural integrity of the structure on the wall. Heats the brick, burns the structural supports. Whose obligation is it to repair what?
Well, I cannot advocate on behalf of the association. It would appear that the association should use the lease agreement to say that the Wendy's restaurant, thereby utilizing it, would be responsible for this cost based on breach of contract and essential negligence in failure to maintain the exhaust vent system that they are given a right to use.
Wendy's then says it wasn't us, it was an electrical problem at your end, and in the meantime, the repairs need to be done. Who is the association going to say is responsible for those repairs? The association or 101?
If the ultimate, well, I guess quite frankly, insurance would probably have to battle it out. But if Wendy's is specifically saying, for the sake of argument, that it was caused by an electrical problem, not by any negligence on behalf of Wendy's, that would appear to be attributed to common area electrical systems.
Okay, and then would 101's internal smoke remediation repairs be borne by 101 or by the association?
I guess it would depend the exact cause of the fire, but I think the sake of argument you're trying to convey to me is that if there was an electrical fire, and I'm saying if that electrical system was a common area electrical system, that may have happened to be in the unit, but was classified as common area elements, part of a much larger electrical system. And that was the cause of the fire. And the argument is that the association failed to have electricians regularly maintain those systems. Everybody would be pointing the finger at the association.
Thank you.
And I would like to
explain the basis of your claim for attorney's fees.
Thank you very much. It's an excellent question. I would like to advocate that if this panel does affirm the trial court's decision with the equitable 50-50 allocation, that is still a successfully brought derivative claim. Cote v. Levine.
Ah, so close.
Oh, let's just hold on a second.
We are live again.
Okay, thank you very much. All right, we had a brief recess, unintended, because we had a little snafu with our technical prowess, and we lost Attorney Levine for a short period of time. You had about a minute and a half left for your argument, and so why don't you pick up now where you were? Thank you.
Thank you, Justices, and thank you. Is everybody hearing me okay?
Yes. We do hear you.
Oh,
yes.
Okay. It was a little lagged. Let's succinct is always best. A successfully brought derivative claim in the context of a corporation or a condominium comes with it an award of attorney's fees. Cote v. Levine requires certain claims in the context of condominiums to be brought derivatively. As reflected on the trial court record, other successfully brought derivative claims did come with an award of attorney's fees. The trial court addressed a whole multitude of issues. This is only one of them. Other successfully brought derivative claims came with it an award of attorney's fees. The reason being is that any funds allocated to the condominium trust are not going to go to the Chamberlain trustees. The Chamberlain trustees own one unit, own 8% of this condominium, and this lawsuit is in the context of a much larger dispute on a whole host of issues against what is a 92% beneficial owner of the condominium.
I'm sorry, I don't fully understand what you're telling me. Are all derivative actions in condominiums, all of which presumably represent a minority share, suing because the majority share won't, are they always entitled to attorney fees?
Yes, Your Honor. That's what I advocate.
A statute or just a case?
There is just a case, and it's not specifically highlighted in Cote v. Levine. Cote v. Levine says certain claims need to be brought derivatively. There's two other cases in my papers that I cited that says in the general context of derivative claims, because most of them come in the form of corporation disputes.
Claim, non-stockholder derivative claims, condominium owner derivative claims. Is that right?
I have not found a case that directly states that, but that is the status of the law based on the connection of cases, and that's what the trial court did recognize at the superior court level.
Has awarded you attorney fees below?
That's correct. Like I said, there's a whole multitude of claims that were brought, successfully brought derivative claims. Some were specific to the Chamberlain trustees. Others were derivative in nature. This is one of the claims that were derivative in nature.
And so you got fees allocated by the trial court based on which were derivative and which were not? Is that what happened?
That's correct.
And that award has been made?
That award has been made, but has not been paid.
Well, that's between...
And part of what I'm seeking is an assessment of damages hearing to kind of figure out all the numbers. The numbers are complicated. I do not fault the trial court for not immediately calculating it because it may not have been before it on the record. But the trial court did award attorney's fees for successful derivative claims because the Chamberlain trustees are stepping into the shoes of the association.
I understand the theory. All right. Your time. Well, that's not for me to say.
No, your time has expired. I will just check with the panel to see if they have any additional questions for you. and I don't see any. I want to thank you both very much. We appreciate your arguments today. We'll take the case under advisement and get back to you as soon as possible. And seeing as that it's still the month of January and the start of a new year, on behalf of the panel, we wish you a very safe and very healthy new year.
Thank you, Justices.
Very much.
Good morning. May I begin?
No, just one moment. That 30 seconds seems like a long time, doesn't it? Okay, now we're live. All right. There is a bit of a lag time between the time that we go live. So good morning and welcome to today's remote sitting of the appeals court. Let me call the case officially. It's JD versus SD 2019-1616. And I have just two quick preliminary announcements before we begin the argument today. And the first is that you each have 15 minutes to make your argument, as you know, because the same rules apply to this argument as if we were in the courtroom, and there is no rebuttal in the appeals court. And second, upon occasion, we do run into some technical difficulties, and if that happens, just please be patient. We'll figure it out, and I'll emphasize that we'll be patient with you, and we hope that you'll be patient with us. All right, so I've already called the case, and so Attorney Anthony, you represent the appellant, so we'll hear your argument.
Yes, thank you. Good morning. May it please the court, Christine Anthony for JD, the husband in this matter. The husband appeals from a judgment of divorce issued by the trial court due to the clear errors committed by the judge and the judge's abuse of discretion with respect to her findings of fact, rationale, and judgment. Specifically, the husband appeals from the alimony and child support orders, the property and debt division, and the provisions related to the health insurance. By way of background, the parties had a 22-year marriage and 3 children were born of the marriage. At the time of the divorce, all 3 children were dependents. The 2 oldest were in college and the youngest was a senior in high school who was headed to college. The husband was employed at a law firm earning $1,634 per week and has health insurance available to him through his employment. The wife owned a hair salon and the court attributed income to her of $480 a week. At all times during the marriage, the parties resided in a home owned by the husband's parents, and the parties never during the marriage paid rent or a mortgage. Early in the parties' marriage, the husband's mother, after the death of her husband, built a home at 6 Silva Street, which became the marital home, with no contribution from the parties. Title is held to that property in the Bento de Silva Real Estate Trust, of which the husband's mother is the 80% beneficiary and each of the parties has a 10% interest in the property. The parties and the children resided in that home with the husband's mother until the wife voluntarily vacated the home during the pendency of the action. The husband continues to reside in that home with his mother and the parties' 3 children, and the children had no relationship at that point with the wife. During the parties' marriage, they took out 3 separate mortgages on the property. The last mortgage that's still in place was for $90,000, and that was the principal balance. During the parties' marriage, the husband's mother also bought 2 other properties with relatives and put her 50% interest in the name of the husband and the wife. At no time did the parties contribute to the acquisition, the preservation, or the maintenance of any of that real estate or the trust interest.
I think that you can presume that we're fairly familiar with the record, although having said that, I undoubtedly will make some gaffe during the course of this argument. But I'd like to just check on a couple of matters in the record to see what is and isn't in before you proceed with your substantive arguments. Am I correct that we don't have the proposed findings and conclusions from either party in the record?
Correct.
Well, it would be helpful then, as you argue, to let us know whether issues were raised in the trial court or not that you argue. And for example, you may be able to answer this quickly. I don't know which one argument you'll turn to first. But your argument that the probate court judge failed to include alimony that the husband was ordered to pay in the wife's income and exclude from the husband's income when calculating child support. Was that argument made to the trial judge?
The argument in the trial court, Your Honor, was that this was not a case where alimony was appropriate. So the calculation that was presented by the husband to the court was one simply of child support. But with respect to that issue, when calculating child support, the court is obligated to include all of the income that either party has under the child support guidelines. So when the court exercises discretion, and it certainly has a discretion to do so. I'm sorry, Your Honor, did you have a question?
No motion to reconsider once the decision came out?
There was a motion for reconsideration. Yes, that was denied by the trial court. I believe that my sister included that in her submissions to the court.
Right. So it was raised after the fact, was my understanding.
It was raised.
Yeah, and is the argument you're making to us now one which you made to the trial judge on the motion to reconsider?
Yes, it was.
Okay.
So when the judge calculated the child support, she's obligated to include all of the income into the guidelines. And that income is that the wife had for purposes of her payment of child support includes the alimony that was paid by the husband to her. And if the judge does not do that, then it really creates a mathematical fiction.
You have a citation for that?
My citation, Your Honor, would be that the child support guidelines specifically include all, it says.
You don't have a case citation.
Your Honor, there is no case law on that point.
How can there be no case law on whether alimony is or isn't included in income for purposes of child support, an issue that only arises many times every day for dozens of years?
I think the answer to that, Your Honor, would be that under the guidelines that were issued in 2018, which were, I believe, the first guidelines that post-dated the Alimony Reform Act, Judge, I think from a practical standpoint, most practitioners have taken the position that alimony is income includable for purposes of child support.
Doesn't it depend on whether you calculate child support first or alimony first? If you calculate child support first, then it wouldn't. And then the fact that child support is paid would have to be calculated into ability to pay on the part of the payor spouse, or in this case, well, yeah, the payor spouse in every case. If you do it second, then you've already made the alimony order and transferred some income, and then you would do then you do it you'd include it. Am I missing something there? What says the judge has to do it one way or the other?
Nothing says that the judge has to do it one way or the other, because the child support guidelines specifically give the judge the discretion to decide how it is that he or she wants to calculate alimony first or then child support. But in this case, when the judge exercised her discretion to first do an alimony calculation, that then becomes income to the wife that she has available to contribute to the support of the children, and it takes away from the husband's available income to support the children.
Was the child support awarded the guideline support?
Yes, the judge calculated the guidelines based on 3 children over the age of 18 in her discretion.
Would it be different? Would it be different if we had changed? I don't remember the alimony is, I don't remember how much, but would it be, how much difference are we talking about if you use the same guidelines, but you reduce the husband's income by the alimony and increase the wife's? Although, isn't this a case where the wife her income is an imputed income anyway, right?
It was an imputed income, Judge.
And so it's higher than with the alimony anyway, right?
Yes, Judge. I think
so.
It's
what are we talking about?
Under my calculations, the child support order would increase to $189 a week and not $77 a week. And the husband's
how can it increase by $120 a week if the wife's income is already above what she gets with the alimony? Just by the reduction in the husband's income?
By the reduction in the husband's income and the increase in the wife's income, Your Honor.
The wife's income doesn't increase, right? Because she was imputed income.
Well, if you were to take the position that the imputed income of $480 a week plus the alimony that she
Why would you add
receives,
the alimony to that?
because that is money that she now has available to her for purposes of child support, and that the husband no longer has available to him. So that changes the calculation.
Her needs were calculated in the alimony calculation based on the imputed income?
Her needs were calculated but in some part, I think, based on the financial statement that she submitted to the court, notwithstanding the fact that she testified at trial that none of her financial statements were correct.
So the judge did not use $480 as the basis of the alimony award?
I believe that she did, Your Honor.
Okay.
Yes,
Obviously,
thank you.
So one background question that's lurking in all of this, which is I do not see in your brief an argument based on Chapter 208, Section 53C2. And I assume that for purposes of this appeal, we are not attempting to reach the proper interpretation of 53C2. Am I in any way mistaken?
And I want to be sure 53C2 is related to gross income that the court has already considered when issuing a child support order. So in this case, the way that the court approached it is that I think my interpretation of her judgment was not that she was using the same dollars twice, but rather that she was simply not discounting from my client's income the amount of alimony that he was being ordered to pay.
Well, there's two anomalies in this case, which I'm not sure the drafters of the guidelines necessarily had in mind when they drafted them. This is a case where one party's paying alimony and the other party's paying child support. And so the whole double dipping notion really is inapplicable in some senses in this case. This is you didn't do a single dip case, as I read your argument, not that this is a double dip case.
Yes, I think that would be a correct summary of it. And it's not an entirely unusual scenario. But in this case, there are not a lot of dollars to go around, and that's one of the issues. And another issue that my client had with respect to the alimony was the failure of the judge to consider the allocation of the debt and the payments that would fall on my client. If I could move on briefly to the property division, my client believes that the court committed an error when it failed to consider all of the relevant 20834 factors when rendering her findings and her rationale. Specifically, the court failed to make findings on the wife's conduct during the marriage, which is a required finding, and she should have made those findings. Secondly, the court failed to consider the discretionary 20834 factors, which were highly relevant in this case, specifically as it relates to the contribution of the husband to the acquisition, preservation, and appreciation of the assets of the parties. You'll see that the majority of the assets that the parties accumulated during the marriage came from the husband's family's contribution, including the real estate on Elm Street and Water Street, the marital home, which is the interest in the trust, the wife's car, the hair salon, and the real estate in Portugal. And in light of the fact that the wife's family made no such similar contributions, the court should not have ordered the equal division of those assets.
I think you actually, the timer notwithstanding, have very little time left. And in the time that you have left, you've claimed that there is a mathematical error in the equal division of the marital estate, because while the wife retained her 10% interest in the Silva property, the husband in the judgment was ordered to pay all of the mortgage payment. And was there any post-judgment practice in this? Was this issue brought before the trial judge?
Yes, it was. And the resulting mathematical error, which is indisputable, the judge indisputably concluded that the assets should be divided equally, but the mathematical error results in the husband receiving 29% of the marital estate and the wife receiving 71%.
I'm sorry,
And was this in the same motion to reconsider as the
Yes.
other? Okay, thank you.
can you explain what was not divided?
The party's interest in the Bento de Silva Real Estate Trust, there is a $90,000 home equity line. And when the court created the chart of assets, it excluded, it did not include the
It didn't
90,000.
exclude it. It included it because it said that the equity value was only whatever, $10,000 or $20,000 each. That's a
Yes.
result of it being reduced, each half being reduced by their own half, $45,000 of the HELOC. Right?
Yes,
So the debt is divided. The only thing that's not divided is the monthly payment, which without explanation is ordered to be made by the husband, right?
yes,
Okay, so the asset division is not wrong. You're saying she should have to pay half of the monthly payment, right?
yes, and also
Okay,
in
but he lives in the house and she doesn't.
yes, that's true, Your Honor. They're under the liabilities, the $90,000 was not listed on his.
It may not be listed,
portion.
but it's implicit in using the equity value of the house rather than the actual value of the 10% that they each have of the house, right? Do you disagree with that?
I would submit to Your Honor that under the liabilities, when you add the $90,000.
You can't add it because then you'd have to add assets, right? Because then the value of the house wouldn't be $20,000 each. It would be $65,000 each.
Yes,
All right, so it's already in there in the reduced asset value. Do you disagree with that?
I think the way in which the judge positioned it, as Your Honor indicated, is that my client the husband is paying for the loan on the property, which increases the value of the property, and yet
But he doesn't have to pay it down, right? He just has to make the monthly payments.
I believe I would have to refresh my memory on that point, but at some point the note does become due.
Sure, of course.
Yes, and at that point, the obligation presumably appears to be falling on him
Well, you
to
could
pay
sell
that
the
note.
property and each of them would just get their equity value, right?
There are 3 beneficiaries, so I believe that the mother would also then need to be a part of the.
Oh, but
sale.
she doesn't, she's not on the HELOC.
She's not on the HELOC.
How were they able to get a home equity loan on a house they don't own?
The bank, they assigned a mortgage and the bank gave them the
They
mortgage.
don't own the building, so who assigned a mortgage? Or they have it in their capacity as, because they are, a trust owns the building,
Yes,
right? They have an undivided 10% share each. They got a mortgage on their undivided 10% share? Is that right?
they did, yes.
In your view, is there any impediment to the judge ordering a transfer of the wife's share to the husband?
No,
under the terms of the nominee trust?
No, there's no impediment to that. And in fact, that is what the husband argues should have occurred because the judge specifically stated in her judgment that this would cause litigation in the future. And the better course of action is to divide that interest as of today and have the husband pay her for her share of the equity in the real estate.
But the nominee trust says a change in beneficiaries has to be approved by all beneficiaries. Was there any evidence that the grandmother the mother would have agreed to this?
She did not testify at the trial, and I don't have any specific recollection on my client testifying to that point. But my client does live with the mother in that real property with the children.
Thank you.
All right, so your time has expired.
Yes, thank you.
I know that the panel had my co-panelists had a number of questions for you. Thank you for answering them. And let me just make sure that they don't have any additional questions before we hear from your sister. I see no other questions. Okay. Thank you very
you.
much.
Thank you.
Attorney Kathawala, we'll hear from you.
Yes, good morning, Justices. Thank you. May it please the court, as Your Honor is aware, I represent SD, the appellee in this matter. I think one of the items I would like to immediately address, Your Honors, is the addendum that is in the brief for the appellee, because at memorandum and order and decision on the 299 motion, which is equivalent to what Your Honors were considering calling a motion for reconsideration, which we now call a motion to alter and amend. I believe, Your Honors, that had this been perhaps more strikingly brought out in the appellant's brief, we would not perhaps be here today or discussing the matters relating to whether or not alimony should be given first or child support should be given first. I draw Your Honor's attention, actually, it's page 26 of the appellee's addendum. It essentially addresses, number one, I believe one of the justices asked, is there a case on this? Well, there is a case that speaks somewhat to this. It is a 128 decision, but it is a Casey v. Sweeney. It is outlined in Judge Melia's memoranda of decision and order, which speaks to exactly the issues that we initially started out with, whether or not alimony can or should be calculated first, whether child support should be calculated first, whether the judge has the discretion to do either first. And of course, I think everyone agrees that is the case. Moving on from there, there is a very thorough analysis, which would have been, I would suggest, very helpful to this court, reviewing exactly how Judge Melia arrived at what she considered to be the way alimony of a non-party versus a party to an action should be considered. And she writes, again, very thoughtfully, in the last paragraph of page 1 of 2 of that memorandum and order, outlining how and why the guidelines give some instructions as to whether or not a party to an action's alimony should be considered in calculating child support. She suggests, by way of her analysis, that no, it should not, that the promulgators of the guidelines specifically talk about a non-party's alimony income. So a non-party to the action.
Isn't that argument carrying a little bit too much, though, when you take a look at section 53C2, and it's very clear, and even though we're not going to apply 53C2 to this case because it hasn't been argued in that manner, isn't it very clear from the statutory language in 53C2 that there are times when alimony is income?
Yes, absolutely. I totally agree with you. I would suggest to you that, interestingly, Judge Melia says, I have discretion to look at it or not look at it, but she refers to a section.
That's her unallocated support analysis, right?
No, Judge. Actually, she talks about the definition of income, and in the definition of income in the guidelines, it talks about that spousal support received from a person, not a
third party alimony. But my point is that to suggest that that means that first party alimony is not income is fundamentally inconsistent with section 53C2, which treats alimony as income.
Well, yeah, I would suggest, yes, it's fundamentally different depending on how you want to define income. The judge goes on further to say, a party to an action's receipt of alimony and the payor's payment of it is for support. And she says, she opines that support is not income, nor is it, nor does she characterize it as any form of compensation. And again, very interesting and thorough analysis. I would suggest to you all of these issues raised in the appellant's brief.
Is alimony deductible for federal income tax purposes?
It is not now, Your Honors, since the Trump's tax law went into effect. It was not allowable as a deduction nor includable as income. I believe that was from 2019 forward.
So until last year, it was income under the federal tax law, and now it is not income.
It is not income now. I believe December of 19 was if you had an order for spousal support up to and including December 31st of 2019, you could deduct that payment and the support was includable. Anything
is that retroactive or for new divorce decrees?
I don't think I understood that question, Your Honor.
I think it applies to the tax years.
So even if you've been, so for example, if you have a divorce decree, and part of my recollection is that sometimes things are used to be at least characterized one way or another for tax purposes, that even if that was the understanding on which you entered your divorce agreement or divorce order was entered, it doesn't matter. Prospectively, every year that you pay alimony, it's now not deductible and not income.
Only for new orders after December 1st, 2019.
What day was this case ordered on?
This was in, I believe it was August.
The motion to the 299 order was heard on August 30th, decided on August 30th, 2019.
So in this case, it is income under federal tax law, both deductible and taxable.
Okay. Yes.
I mean, I understand that isn't controlling, but.
So, but for that reason, among many, is another reason to look at what she calls unallocated support. What is unallocated support?
Well, it is support that is characterized as part child support and part spousal support, but is never delineated as such. It is unallocated.
Except that he's not paying child support. She's paying child support to him.
She is indeed, yes.
Okay.
So moving on, I'm just suggesting again, the other issues relating to the property settlement and the health insurance, which we did not touch upon, but which is statutory and is referred to in my brief. Those were all raised in the 299 motion. They were spoken to, but I think the last health insurance one was not. The judge made a finding or a conclusion when she denied that motion that the other arguments were without merit. I would suggest going back, I do not suggest there is a miscalculation in Mr.'s gross income, which my sister brought up as a mathematical error.
Can I ask about the HELOC?
In the judge's.
Can I ask about the HELOC? So as my questions to your sister indicated, it looks to me like the debt itself has in fact been divided between the parties in deciding what the value, equity value of the 10% interests are in the trust. Without any explanation, though,
Correct.
The judge orders, one of the first lines of the order is the husband has to pay on time the HELOC payments. Can she do that without explaining any reasoning for that? I'm not saying it's an abuse of discretion inherently, but I don't. You could do it either way, right?
Well, yes, I mean, she could have been silent on it. I believe, and I'm suggesting that your questions to my sister sort of resolve that. The individuals were, who live in the house, it's a form of rent. Miss SD, the wife, has to pay her own rent. And the only debt associated that both of the parties owe is that HELOC loan. Mr. is in the house, and I can't recall exactly what that monthly payment was, but nonetheless would be an equivalent as to rent that would be the same as SD paid. And I think that is why she said his obligation to pay and go forward with payment. I think she was essentially also saying, I'm not letting this fall to you on a monthly basis as you are utilizing an asset that, by the way, the wife, FD, could say, well, if you're going to make me pay, then I'm going to charge you a fair rental value. I mean, I think
well, I mean, you say fair rental value. Of course, I don't know enough about this HELOC or the arrangements. I don't really understand how two tenants can get a mortgage on a house without the third one. I don't know, because foreclosing is going to be hard. But in fact, anyway, I don't know. But so, but what I'm trying to figure out is, so each monthly payment presumably is partially principal and partially interest. Do we have the terms of the HELOC? Is the HELOC in the record?
I believe that was one of the exhibits.
Okay, we'll have a look. I'm just trying to figure out, at some point, is there a balloon payment of all the principal or whatever? And is your view that the husband is obligated to pay that, or just these carrying costs of whatever percentage interest and whatever percentage principal? And
I believe that my understanding is that the husband would have to pay the monthly obligation as was listed on his financial statement, and going forward. How they, I mean, and I'm sure when you read the part of the transcript that relates to the other properties with petitions to partitions all being held by different individuals, there seems to be an issue in some of these matters with respect to no initiating note. So that's even more compounding, which I believe came up at the trial, but I'm not sure precisely. I know the appellant had a relationship with the bank, which is, I'm sure, how he was able to obtain a HELOC on a piece of property without all three owners or the trust signing on as all three of them acknowledging it.
So your sister has indicated that the 299 motions that were filed also covered this issue. Is that your recollection? Because I'm not seeing any reference to it in the order that's appended to your brief.
Well, unfortunately, I should have probably put in there the appellant's 299 motion. I believe the suggestion that it was in there. These issues were raised.
Okay. Then could we just have a copy of the 290? Could you provide the clerk's office with a copy of the 299 motion and the response?
Yes.
Were the proposed findings and rulings entered into evidence for both parties?
When you say entered into the evidence, Your Honor, do you mean up to the appeals court in the appendix, or do you mean submitted to the court? We did, at the close of the evidence, both parties submitted request for findings of fact, rationale, conclusion, and the whole thing.
Were they marked as exhibits?
No, they were not, Judge.
Do you think it's necessary that they be so?
Was your question, do I think they were
necessary? Is it necessary to do that in the probate and family court or not?
No, Judge, it is not. They're just, they're requests for, they're basically, while we file them, actually just, if you go to the civil version of this, it's a request to a judge to make these findings.
I understand. I understand. I was concerned that there might be a different practice in the probate court.
I'm sorry, I know your time is short. I'm looking at a HELOC. I don't know if it's the only one. It's to Anna as well as the other two. Are you sure that she is not a co-borrower on whatever HELOC is currently effective?
That's a question. I'm not sure, Judge. Is that the HELOC on the?
I don't know. I'll have to look. Thank you. I mean, at least I know what I'm looking at.
Thank you.
All right, thank you very much. I see your time has expired. I'm going to check with the panel, however, to be sure there's no additional questions that they may want to ask of you. And I see there's none. Thank you both very much for your arguments. We had a lot of questions for you, and you've answered them well. We appreciate it. It's still January, so on behalf of the panel, I'm going to wish you both a very healthy and very safe and happy New Year.
We're live.
Okay, thank you very much. And it's still morning. Good morning, and welcome to today's remote sitting of the Appeals Court. My name is Ariane Vuono. I'm joined today by Justice Peter Rubin and Justice Mary Sullivan. Just two quick reminders before I call the case and we hear your arguments. And that is you each have 15 minutes to present your side. There is no rebuttal in the Appeals Court. And the same rules regarding oral argument that would apply in the courtroom apply as well on this platform. The second reminder is upon occasion, we have some technical difficulties. If that happens, we ask you to please be patient with us, and we assure you that we will be patient with you as well. With that preamble finished, I'm going to call the case officially, 154 Turnpike Road versus A Beautiful You, Inc. and another, 2020-0532. Attorney Broadley, you go first.
Thank you, Your Honor. May it please the court. I am, yes, Stephen Broadley of Errant Fox. I represent the appellants of Beautiful You, Inc. and Elliott Lack. This matter is not complex. The appellee landlord, the plaintiff below, contends that my client is responsible for holdover rent at 150% of normal rent from the time his lease ended in September 2013 until he vacated the premises in 2017. But my client paid all the rent that was charged from October 2013 until February 2017. The plaintiff commenced suit to collect holdover rent in early 2017. Our position is by then, the plaintiff had waived the right to assert that holdover claim despite a specific release provision based on its consistent contrary conduct. There was a bench trial in Worcester Superior Court on August 22nd, 2019. The trial court agreed with the plaintiff and entered judgment accordingly. We contend that the decision was error. My client contends that the plaintiff's conduct and communication from the end of the lease term until November 2016 was so consistently at odds with what is now argued that the right to collect holdover rent was unilaterally waived. As you will have seen, virtually every fact necessary to decide.
Let me just ask you if I may interrupt for a moment. It was yes. Evident at trial, based on your client's testimony as well, that he was aware of the holdover provision in the lease, correct?
He was aware that it was in the lease. Yes, he did say that.
Right.
And we acknowledge that.
And
yes.
Right. And in fact, there was some discussion about it after the original lease expired.
There may have been one or two times that was discussed. One of the plaintiff's witnesses said he never had any discussion with my client about holdover rent at any time.
Right, that was the one that Mr. Fitzgerald, who came on a little bit later. But the judge here found, after having listened to that testimony, that there was in fact not a waiver. So is your view that whether or not there is a waiver is a question of law that we can decide, or is that a question of fact that we have to accept unless it's clearly erroneous?
Well, I would prefer that it be a question of law. I think that if it's a question of fact, as argued by the plaintiff, then I think it was plainly wrong. That's what I think.
Okay.
Did you
Is that a
argue promissory estoppel below?
We put in evidence of reliance. There were no closing arguments. I believe that it was in the submission that I made to the judge after the trial, but we didn't have a closing argument.
When you say after the trial, I mean after judgment or between trial? Was it a post-trial brief?
Yes, there were requests for findings and rulings submitted by both sides.
And yours included promissory estoppel.
Yes.
The judge didn't really rule on that, did he or she, in the findings?
He did not do so. He didn't make any findings about reliance or anything that would be necessary for that.
In terms of waiver, you're calling it waiver, but you're saying it's unilateral.
Yes.
And of course, the agreement says that waiver has to be mutual, blah, blah, blah. And presumably you can modify the agreement through mutual agreement. Are you arguing latches or something different?
No, I'm arguing that I didn't make a latches argument, but I'm arguing that consistent behavior for a three-year period was so strong that it overcame, and it's possible to overcome and to waive even no waiver provisions in leases if the evidence is sufficiently strong.
Do you think that it matters that the without rejecting that argument, if there had to be a writing for the waiver, do you think that the invoices might count as such a writing?
The plaintiff made a big deal about how the invoices were supposedly just courtesy, but they couldn't deny the fact that they were out there. They were out there and they were representations made by the plaintiff. There wasn't any writing back, but I would say that they were just one more bit of evidence to show the unilateral waiver. Did the landlord send you a proposal for new rent going forward? There were, and in the evidence, there are two proposals that were made by the landlord. Neither one of them came to fruition. Am I correct that they were for rent less than the then current rent in each case? That's certainly what my client wanted and expected, and I believe they were. So, well, I'll ask your brother about this. So to the extent their argument is you knew and should have expected this, the fact is that should have expected to be charged 150%. We're just forbearing on asking for it pending this negotiation. The actual value of the premises, which remained leased and from the money from which benefited your brother's client, in fact, the value of the property was less than the prior rent, the market value. My client would contend that they weren't entitled to charge the rent that he continued to pay. His argument was that they paid off they recovered all their costs, and so they should lower the rent. But I agree with you, if the plaintiff was willing to rent it for a lower price, then the market price was arguably lower, and my client overpaid. But he paid consistently. But it's not as though this is a circumstance where everyone knew this was going to be $9,000, $10,000 instead of $6,000, and you guys were just lucky to pay the $6,000 and we're trying to pull a fast one. It's really the opposite, right? We weren't getting a break by doing this, if I can restate that. And the judge made no findings about that either, about the intent, about the reasonableness of treating those invoices on your part as valid invoices, nothing like that. If we find that that important facts weren't found, would the proper thing to do be to remand for a new trial or for further findings, right? So for example, if subjectively you weren't relying, then it's not promissory estoppel, right? You've decided every month not to move out.
But if in addition to the invoice, you had received a phone call saying every month, this is just a courtesy, really, you owe us the holdover rent, which I know there's no evidence of, the judge could find, well, they didn't really rely on this. So would we have to remand for more findings or for a new trial?
Well, I have at least one decision, Bruno v. Bruno from 1981, which I think permits you to make additional findings that don't conflict with the trial judge's findings.
I don't see our court making a lot of findings of fact in the last 30 odd years, but okay.
Only one case, I said.
But here it was actually directly addressed in front of the judge whether or not your client relied on the invoices as being the amount. And the judge specifically credited testimony that it was only a courtesy and that there was no reliance on that.
Yes, my client's testimony was he thought he was overpaying, but he was willing to do that even though it smelled, and he thought he was overpaying because it allowed stability going forward.
Right, right. There was a reason why he didn't want to move. I mean, he had a practice there, an active practice.
Wait.
Yes.
I'm not following. I thought that there was no finding. I thought the finding was that any reliance wasn't reasonable, not that there was no reliance.
I don't think it's really either one. What the judge said was, as I recall, and of course we'll double check.
Yeah, I don't have it.
With respect to the invoices that you, if I may say, correct me if I'm wrong, with respect to the monthly invoices that you claimed were showed that was the only amount that was going to be owed, and the failure to include the extra rent, the holdover rent in those invoices was conduct that shows that there was a waiver, correct?
Yes.
But the judge found that you could not rely on those invoices for that reason, because as the judge said, they were merely and only a courtesy. That was that the amount of rent due and when it was due and how it was due was spelled out in the lease.
Well, I guess I must say that if sending the invoices is merely a courtesy, then I don't understand the courtesy here, because if the landlord for 3 years sends an invoice that says X, and then 3 years later turns around and says, oh no, for all that period you actually owed X plus 3,000. I don't see that as a courtesy. Maybe I have a different definition of courtesy. If they say that it wasn't required.
I can certainly appreciate that, but the fact of the matter is that here we do have a judge that was able to, he listened to 3 witnesses, and including your client, and determined that was not something that you could rely on. So is that now a question of fact? So I guess that's certainly a question of fact that was resolved by the trial judge. But I guess your point would be that it was plainly erroneous because nobody could find that under the circumstance.
I would say that his finding that it was a courtesy, I would take to mean they didn't have to do it. They didn't have to do it, and they specifically said so. The clause on regular rent says that you're supposed to pay it without any previous demand. But the fact they sent it as a courtesy, I think the fact stops there. I don't think he made a finding that my client couldn't rely on it.
I don't see that finding either. What I find is, this is at the bottom of page 37 of the addendum to the appellant's brief, page 4 of the judge's opinion. The fact that the landlord continued to invoice on a monthly basis the tenant for the original commercial lease rental amount is not sufficient to overcome the applicable presumption. That is the presumption that the lease wasn't modified. I mean, and that strikes me as a legal question, I think. Maybe
well, factually, correct me if I'm wrong, but the lease ended in 2013. A no waiver notice was sent in 2014. A deficiency notice was sent in 2016. And then the additional rent was billed in 2017. Is that correct?
Yes.
So
also,
the question becomes, can the receipt of, let's call them volunteered invoices, we won't say whether or not they were an accommodation or a courtesy, in the face of the no waiver notice sent in 2014, would require the judge to conclude that the evidence was sufficient to overcome the presumption, or whether the judge could look at the no waiver notice and the deficiency notice and say, given those, I don't think sending these bills was enough. How do you address that?
My position is I look at, and I know you can't just make a pile and compare the size of the piles, but I look at the one thing that went out in that 3-year period, which was a reservation of rights, a phrase in the middle of a sentence that talks about paying a small overdue amount. And that's the one thing on one side. And then I look at the things on the other side, and I don't think we're entitled to ignore the fact that those invoices went out. Courtesy or not, they were communications between the parties. And they didn't come out saying, well, take it or leave it, but here it is. They went out saying this is the amount due, and that was the exact amount that my client paid every month.
So to paraphrase somewhat colloquially, I think your brother's argument was we were happy to do that while we thought we were in productive lease negotiations, but we were strung along. My words, not his, but I think that's the import of the argument.
No, those were his words.
Those are pretty close. Pretty close.
And when the whole thing fell apart and they disappeared on us, we got to say, okay, it's over, and assess the past due amount. How do you respond to that?
I will say that I see in their brief where they say the lease negotiations went on 2014, 15, and 16. But then when you come to the actual testimony at trial, you have no written communication about any of that after February of 2014. And neither one of the witnesses could put any times to any specific communications back and forth about when they happened. They just said, oh, he would always come up with this, he would always come up with that. Not a lot of specificity there about exactly what went on and required them to stop doing other things for 3 years.
Isn't that precisely the situation in which we are required to defer to the judge's fact finding based on the demeanor of the witnesses and the somewhat ambiguous testimony he heard?
You have to give that credit. But I think that doesn't mean that you can ignore the things that were very definite in here. And the documentary evidence is very definite. See, my time has expired.
Your time has expired. I'm going to check with the panel to see if they have any additional questions for you, and they do not. Thank you very much for your argument. We'll turn now to Attorney Gibbons.
Thank you, Your Honor. May it please the court, Robert Gibbons for 154 Turnpike Road, LLC. Your Honors, on the waiver issue, in order to qualify as waiver, it has to be unequivocal conduct on the part of 154 that they intended to waive its right to accept the holdover rent. The court specifically found that there wasn't that conduct because, yeah, the courtesy, I think using the court's word, the courtesy invoices went out on a monthly basis. But in parallel with that, Mr. Fitzgerald did testify on direct examination that when he first met with Dr. Locke in May of 2014, he did mention to Mr. Locke that he was currently in holdover status. That was in May of 2014. Then again, in October of 2014, a letter goes out from 154 Turnpike saying, hey, you're in default of your payments. And by the way, you're still in holdover status because your lease terminated back on September 30th. Then you fast forward again in 2016, they sent another letter saying, hey, you're in default and your holdover provision is still in effect and we're not waiving it. You're on the hook for holdover rent. And then again, beginning in February of 2017, they began to send invoices reflecting the holdover amount. So you've got four instances there where that's not unequivocal conduct that they were waiving.
The judge says the landlord received nothing of value in the exchange, and there was no consideration provided to the landlord for the proposed waiver and/or modification of the lease provision. That's wrong, right? You got rent every month from these people and didn't have a vacant place. So there was consideration, wasn't there? Why isn't you're sending an invoice and them paying it in full and not leaving you with empty space that, by the way, you specifically told them was worth less than what they were paying, why isn't that consideration? Why isn't this a modification just under basic contract principles?
Your Honor, on that question, the consideration that was being received was consideration that they would have had to already, actually would have already paid that rent plus the holdover rent. That was the consideration.
No, you sent them an invoice. You sent them an invoice for their old rent. It's $6,000, right?
Approximately.
About $59.90 something. All right, so you send them, first, you send them a proposal to renew the lease at a lower rate, at less than $6,000 a month, right? And your idea is that during negotiations for less money, you have somehow reserved the right to bill them more money. I don't get that. I really don't get that. And particularly if there's an equitable principle here, like promissory estoppel, I don't get it. But it seems to me the judge is wrong about consideration, that you received a benefit, which is not a vacancy and rent above market value, and you took it for 3 years and then jumped them with a $100,000 bill at the end. I just don't see how that has, I just don't see how commercial relations are supposed to work like that.
Your Honor, consideration, I believe there was 2 proposals that were provided, one before the lease actually expired, and then another one after the lease.
Yes,
expired.
I've done the math. Both of them are under market rent. The second one is $2,000 below, not market rent, below what they were paying. The second one is for $4,000 a month, not $6,000.
Maybe, yeah, during the initial year, Your Honor, then of course the rates would go up. The consideration there, Your Honor, would be that what my client was looking for was to have a long-term lease.
What's the benefit? I don't understand what the benefit is of that. You don't know if you could have even found a tenant. I don't understand how you're harmed in any way. You have him there, he's paying above what you can get on the market. Why wouldn't you keep him as long as you could? Were there no tenants in 2017, but there were in 2014? I don't get it.
Your Honor.
There is a value to a long-term lease.
Yes, at a lower rent.
Your Honor, the value is that, my client was negotiating in good faith. There was a tenant that had been there for a while.
Yes, negotiating for rent below what he was receiving.
In exchange for a longer-term lease.
Let's let him answer his question, please.
I just think this is.
Go ahead.
No, I understand what you're saying, Ron, but in the commercial leasing arena, tenants are often willing to take, landlords are often willing to take less monies in the initial years of a new lease because they get the benefit of a long-term lease, knowing they now have a tenant who may be liable for the next 5 to 10 years. Here, Your Honor.
Were your offers for 5 to 10 years?
I don't recall the exact. There were more than 1 year, Your Honor.
I understand. Well, they stayed for 3.
Excuse me, Your Honor. I'm sorry.
The tenant stayed there for 3 before you told him you want another $100,000, right? Not you personally.
Your Honor, it was a tenant. It was the tenant here, a beautiful Your Honor, who actually wanted it both ways. Dr. Locke even testified he had the flexibility to leave anytime he wanted, and he made a business decision not to execute the new lease. Notwithstanding that, we were trying to negotiate with him to have a new lease in place that would have been several years out. So therefore, the landlord would have been inclined to take less in the initial year. But that lease, those monthly lease amounts would have gone up as the lease moved on. The waiver here, Your Honor, is it has to be unequivocal. I would agree with you, Your Honor, if in fact we had never once mentioned about the holdover provision. There could potentially be a waiver, but it has to be unequivocal. They had 4 times they were saying, hey, we're not waiving our right to the holdover rent. And notwithstanding, Dr. Locke admits he never once responded to either the letters that contain that representation about the holdover rent, nor did he ever respond to any of the proposals. He never provided his own proposal back. Instead, what he did, Your Honor, he did string the landlord out. He made all these complaints about conditions with the premises, which the court below specifically found were immediately addressed, and they were just minor problems.
Okay, but you were offering him less rent. Your argument about the value, your client's belief about the value of the premises was they are not worth what we're currently charging Dr. Lack. We're proposing a reduced rent for him going forward. You can say you were in negotiations, this, that, I don't know. You didn't mistakenly once send him an invoice. For 3 years, you sent him invoices stamped paid in full, right? So I don't know what to say. The equities of this don't seem to me, I mean, maybe you could show some damages if you could show that you would have been able to lease it in 2014 or something. Maybe he breached something, I don't know. But to me, I just don't see suddenly jumping him with $100,000 bill 3 years later. It doesn't, I don't see how it adds up. If my landlord, I don't have a landlord, but if my landlord one day, after having sent me invoices for years that said 6,000, told me, listen, 9,000, and you owe it retroactively for 3 years, I'd flip.
Well, let me just intervene for a moment here. Let me intervene for a moment, if I may, because of course, in this case, we did have a trial judge who listened to the testimony and did not make the kinds of findings that hypothetically, Justice Rubin is pointing out to you right now. In fact, the findings that the judge made were that Mr. Latch, Dr. Latch, Attorney Broadley's client, was at least aware of and knew of the provisions of the lease. And we don't really know whether or not it was a good deal or a bad deal to reduce the amount of the monthly rent in a new lease, because there was no evidence taken on that issue. But is that fair to say?
That is fair to say, Your Honor. In just using your jumping on, this wasn't something this is not a surprise bill. This is a negotiated term through sophisticated commercial, landlord and tenant represented by counsel. They negotiated the holdover provision. That was in there. It wasn't a surprise. Dr. Locke knew it was in there.
If it wasn't contractual modification with consideration, and I'm not sure it isn't, the judge never ruled on the promissory estoppel claim.
For a modification, Your Honor, I would agree. You actually need there's two things you need. You actually need intent, to overcome, attempt to overcome that presumption. It has to be evidence of sufficient force to overcome the presumption that the parties intend to be bound by their agreement. And you also have to have valid consideration. The court, and I know you disagree, the court below specifically found that there wasn't valid consideration, and the court also said there wasn't enough there for the intent. Because
okay, I agree. I think I agree with that. What about the promissory estoppel claim? If in fact they relied to their detriment on your invoices for 3 years by not moving out and leaving you with a vacant space, shouldn't the judge make findings about that?
Well, I think the judge didn't make specific findings, and I'd have to go back and look. I'm not even sure that promissory estoppel was ever even argued. It certainly wasn't argued at the lower level that I recall.
There was no real evidence of that. There was a comment, there was an issue in the proposed findings that was filed by your brother, that there was some reliance on the part of a client. An actual argument of promissory estoppel, I didn't see in the record.
And I guess my response to that would be, again, I would agree with that if there was not these 4 intervening actions where the tenant was clearly put on notice, hey, we're not waiving our right to the whole of our provision. And I'd also like to point out one other fact to the court. I don't think it's in either brief or in the findings, but Dr. Locke, the principal of A Beautiful You, he did testify when asked on examination. He was asked, did you have something electronically triggered in your accounting system to pay rent regardless of whether you got an invoice? The answer was, I did. And I said, okay. And then the answer was, yeah, it was an auto pay. So he already had set up in his system that he was automatically paying the amounts that were referenced in the lease. I find that very hard to believe that he was relying on these invoices when he already had these payments set to auto pay. When the lease expired on September 30th of 2013, he didn't change it to 150%. It just was auto pay. Just like when the invoices were automatically going out as a courtesy by the landlord, he testified he had it set on auto pay. He wasn't waiting to get that invoice, seeing what it was, and then paying the amount. He had it set up in the system.
What does a courtesy mean? How is it a courtesy to misbill someone? I don't understand.
Your Honor, because it's the lease itself that governs the terms of the parties' agreement, absent a modification or waiver. And of course, our position is there was no modification, there was no waiver. So regardless of whether these invoices went out, the tenant was liable to pay rent by the first of the month in the amount stated in the lease. And when the lease expired, based upon the terms that were previously negotiated, he was obligated to pay rent at 150%. Now, in good faith, the landlord negotiated with him and to try to enter in a new lease. And I know that you disagree on the consideration, but the consideration that would have flowed to the landlord would have been a new lease for some set period of time, not Dr. Locke deciding when he decides to leave, when it's convenient for him.
I mean, obviously I see your point about, about wanting a long-term lease. It's just hard for me to assess the value of that. You were negotiating for a price lower than what you were getting. Maybe that's why you didn't complain for a year and a half, because if you sign the lease, you'd only get, $5,000 and change, and you're getting 6. So, I mean, I don't know. These are facts for a judge to throw, but I just feel like I think the judge didn't grapple with any of this.
Well, because, Your Honor, I think regardless of what the lease proposals were, that doesn't change the underlying lease that already served as the parties' agreement. You have an underlying lease, expires, that's still that moving forward, that governs what the tenant has to pay. The tenant has to pay 150%. Just because they're negotiating a new lease, absent an actual waiver, which in the courts found, there wasn't the evidence here of a waiver because there wasn't unequivocal conduct. I would agree. If the landlord had not said one thing for 4 years about holdover rent, you might have unequivocal conduct. That's not what happened here. So regardless of what the new parameters of a potential new lease were, that didn't matter. That didn't change the terms of the underlying agreement that this tenant was on the hook for 150% of rent.
But I mean, we're not in disagreement about the law, I don't think. The case law does say that the formalistic examination of only the text of this lease is not the end of the inquiry. But I agree with you, there has to be sufficient force to demonstrate a waiver. That's clear.
Yeah. In addition, Your Honor, the conduct here, and the court found that didn't find that there was no 93A. Didn't find it wasn't the landlord who was trying to string along the tenant. It was just the opposite here. The tenant complained during testimony about all these alleged significant issues. The court, the fact finder here, determined, hey, those issues were minor. You know what? And the property management company addressed them right away. And the other point I'd like to make to the court is that, there wasn't an anti-waiver provision in this lease. And the question of whether there's a waiver is a question of fact. And one of the circumstances that you consider is, was there an anti-waiver provision in the lease? And there was an anti-waiver provision here. Now, I would agree it can potentially be waived, but to have that, to waive a right plus waive a anti-waiver provision, you've got to have really unequivocal conduct. I mean, you would have had a
I'm going to stop you there because your time is up. Okay. I just have 2 comments to make before we stop. And that is, of course, we ask a lot of pointed questions, and we do that on purpose so that we really can get to the bottom of the issue. And no one, of course, should take anything from that. Second thing I wanted to say is I did notice that the trial judge in this case complimented you both for your professionalism and your civility towards one another. And that we don't always see that, and it was nice to read that. But the case didn't get settled then, and it hasn't gotten settled now. And it doesn't seem to me this is the kind of case where there's a lot of in-between room. It's either going to be one side or the other. Given that civil relationship that the two of you have, as commented upon by the judge, do you want any time to discuss this matter before we render our decision?
Your Honor, I would be happy to discuss with Attorney Bradley, the potential resolve. This case.
Well, we're going to take this case under advisement. We usually work pretty quickly, so I will tell you that we will not issue an opinion for 10 days in case you want to come back to us. And after that, if we don't hear from you within 10 days, we're going to go ahead and make our decision. Okay?
That's fair.
I appreciate it. Thank you.
On behalf of the panel, I just like before you leave, it's January, so it's still part of the new year. We wish you a very safe, very healthy new year.
And the same to all of you.
Thank you. Thank you.
We are live.
Okay, thank you very much and good afternoon. I'm going to call the case, and then I just have a couple of reminders for all three of you before we begin. A Department of Children and Families versus Another and Mother, 2020-0792. I want to remind you, even though we're on this remote platform, this is being this is live, and so and the case is impounded. So please remember that and not use any of the real names. We've already gone over the fact that we're going to be splitting time with respect to the department and the child. Attorney Rosenthal, you will have 15 minutes to present your argument with respect to the mother. And as I think you likely know, there is no rebuttal in the appeals court. And lastly, just to let you know, in the event that we had any technical difficulties during the course of the argument, we ask for your patience. We will be patient with you. Generally, they get resolved very quickly, and your time will not be lost if that happens. All right? Okay. Attorney Rosenthal, please begin your argument.
Good afternoon, Your Honors, opposing counsel. May it please the court. First off, let me apologize. I misspoke when I wrote in the appellant's brief that the trial judge issued her findings of fact the day after additional testimony was given. Actually, the trial judge issued her decree or decision the following day after that testimony, and her findings and conclusions a couple of months later. The fact remains that the judge heard testimony from Patricia Stewart, DCF's area case manager, that the child was an emotionally healthy little boy who can be successful in transferring attachments to another family. You'll find a portion of her testimony on page 18 of my brief. There was no mention of this testimony and no effort to discount it in the judge's decree or in her findings. That testimony was the only evidence regarding potential harm to the child if he were to be adopted by kin instead of the foster parents. Child's Appellate Counsel has argued at page 39 of her brief that there was absolutely no evidence that showed child would definitely not be harmed. Once again, no effort was made to rebut the undisputed testimony of DCF's own area case manager, which indicated that a transfer can be successful. She also cited no case law to support her argument that mother or the V family had the burden of proving that there would definitely be no harm to child from a transfer. This argument, if accepted by this court, would unfairly shift the burden of proof to the party seeking a transfer. At a minimum, DCF had the burden of going forward on this issue, and the preponderance of evidence that was heard on this issue favored a transfer. The judge based her decision only on what she considered a reasonable inference, but never addressed Stewart's testimony in her findings, indicating that she did not pay close attention to all of the evidence or provide an even-handed assessment of the evidence. With respect to mother's argument that DCF's actions stacked the deck in favor of the foster family, this case is distinguishable from the Ilona case. In that case, the mother complained that DCF had failed to provide adequate services. This case involves not the services provided by DCF, but the manner in which it prosecuted this petition. DCF not only fast-tracked the termination of mother's parental rights, but it also slow-walked its efforts to locate and accommodate the V family. DCF opposed the V family's effort to intervene in this case on the theory that their interests were in common. But throughout the trial, DCF's attorney argued in favor of the foster family and downplayed Stewart's testimony, never even mentioning it in her final argument.
I'd like to understand your argument regarding timing a little bit better. There was a period in this case before the goal was changed to adoption. Even though I believe this was either the third or fourth child that would be headed for DCF custody. Are you saying that they should have started to look for alternative family members even before the goal was changed to adoption, or that they reacted insufficiently quickly after the goal was changed to adoption?
To a lesser degree, the former, and to a greater degree, the latter.
Right.
DCFs.
So wouldn't it be, I was concerned that that might be your argument. Isn't it a little bit inconsistent with the goal of reunification to say that the department has an affirmative obligation to start looking for substitute parents within the family?
I'm sorry, Your Honor, I can't cite chapter and verse on this, but I've cited in my brief DCF's regulation, which says that kin should be considered for placement as soon as a child comes into DCF custody.
Right, but this understood, but in the most of the cases we see, what you find is that there's an aunt or an uncle or a grandparent who lives near the parent with whom one is attempting to reunify. These folks were in New Jersey. So if they had considered them at the time, that would have meant an utter disruption of the bond with the mother.
Well, again, at least the investigation into the availability of kin as a placement should have begun earlier. The fact that the V family is in New Jersey is certainly not the other side of the world. And in any event, it was clear that once adoption became, if not the stated goal, then the de facto goal of DCF in this case, there was little or no effort to look for kin, other people besides other relatives besides grandparents, until the goal officially changed several months later to adoption. May I continue?
Yes, please.
Okay. So what I was saying before is that DCF opposed the V family's effort to intervene in the case, but throughout the trial, even though neither family had been approved, the V family was approved during the course of the trial. The foster family not until after the initial part of the trial had ended. But throughout the trial, DCF's attorney argued in favor of the foster family and downplayed Stewart's testimony, never mentioning it in her final argument. If DCF was actually representing or had interests consistent with the V family's interests, then I think you could argue that the V family had ineffective assistance of counsel. The trial judge made much of the fact that the V family did not show sufficient appreciation for the bond between the child and the foster family. The evidence at trial, which once again, the trial judge did not address, indicated that the foster family paid only lip service to maintaining bonds between the child and his biological family. Foster mother admitted that at no time since she attained custody of this child from July of 2018 until the time of trial, she had not arranged any visits with the child's two biological half-siblings, none. She also objected to DCF's search for a kinship placement in November 2018 when child was less than 5 months old, claiming without any evidence that that would be detrimental to the child. The trial judge didn't take any of this evidence into account either. This is not, as far as the degree to which the V family was related to the child. This situation is not like, it's not like the laws of descent and distribution, where there's a hierarchy of people who are accepted or an order in which people receive benefits from an estate. In this case, DCF's regulations and Massachusetts law indicates that kin is an important element in the placement and ultimate adoption of a child. And in this particular case, the fact that that the V family was, I guess, a third cousin of the child shouldn't matter. I don't see any case law anywhere that draws those kinds of distinctions. So for all of these reasons, mother requests that the court reverse the order approving the adoption of the child by the foster family, and that this case be remanded for further proceedings. I'm available to answer any other questions the panel may have. Otherwise, I would rest on my brief.
Okay, well, thank you very much. Let me just double check with the panel. No, I see no questions. Thank you very much. We'll turn now to the department and Attorney Peterson.
Good morning, Your Honors. Excuse me. My name is Jim Peterson, and I represent the Department of Children and Families in this case. The judge did not abuse her considerable discretion in this case when she determined that child's best interest would be served by his placement and eventual adoption by the foster family in this case. And that is the touchstone of these cases and this analysis, the best interest of the child. That's what, once there's a determination that the parent is unfit and the parents, or in this case, both parents, parental rights will be terminated, the judge has to determine what's in the best interest of the child, not in anyone else. And here, she did give close attention to the details of both families and made extensive findings about the condition of both of them. And she found several differences and several things that benefited the foster family in this analysis. Specifically, she found that where they're located, rather than New Jersey and Massachusetts, was important in this case because it facilitated easier communication with the biological family and the biological extended family. We know that the paternal grandparents who were involved, they came down and actually met child in the foster home and actually told DCF, if the foster child is going to stay here, we're not interested in adopting. But they were involved, so they are there. They're not just mythical. They live in New Hampshire, as apparently off and on so does father in this case. Mother's extended family, or closer extended families, all in Massachusetts. And the child's, or the foster family rather, have another adopted child with whom they keep those connections, those biological connections open. And so they have a demonstrated ability of doing this. And this location or geographical proximity played a part in why they were better. But also, so does the bond with family. In fact, this was with the foster family. In fact, this was the only family that child had ever known. The foster mother came and attended to him while he was still in the hospital. And mother left at that point, and he went home. Child went home with the foster family, with foster mom, foster father, and the sister. The foster parents have a child, another child that they've adopted as well. And the child does have a bond with the sister too. There's also stability in that location. And also the judge found that the cousins' dismissive attitude towards the foster parents and their inability, that they don't seem to acknowledge the value of the bond between child and the foster family, the whole family. And in fact, wouldn't even acknowledge that the foster daughter, the foster family's daughter, was child's sister. They called her. Instead, the testimony was, no, that's just the foster parent's child. And there is this bond, as the judge found. Child lights up when his sister, his foster sister, comes into the room. And so there is this bond, and they didn't seem to appreciate that there was a bond, that this might be traumatic for the child to be removed, and that this did count against them in that. Otherwise, though, the judge made multiple findings that really didn't favor one side or the other, but she did so in a detailed form. For example, so I just note here, they both own their own homes. Both of them were going to give a child to the bedroom. They were both financially able to support child. They both had a safe and stable environment and were going to give unconditional love. That's a summary, but the judge in her findings go into detail about where each party works, how, like the foster family, when the foster parents are gone, who takes care of the child at that time? How does that work? How does the transfer work? The judge made extensive findings on that. It's just that when you get down to it at the end of the day, none of those favored one or over the other. But Mother implies anyway that the only thing that was considered was a bond, and it wasn't. It's just that the bond, along with the geographical proximity, the stability, and the cousin's dismissive attitudes, were the things that were different between the two families. And all those things favored the foster family in this case. I would just like to address a few things. The reopened hearing, as counsel did mention, it wasn't mentioned in the closing argument afterward, APM Stewart's testimony, that all of that was open for a limited purpose. However, none of that was open to reopen the evidence. The judge, in fact, was very clear on this, that she had the evidence. In fact, DCF's position had gone to the cousin at this point. We were backing the cousin at that point. But the judge was very clear that she didn't care what DCF's position was, quite frankly, because she had the evidence. She had heard the testimony, from both of the cousins, the Mr. and Mrs. V, from the foster mother, from the adoption worker, from all of these places. She had all of the things that are also appear in the record appendix, all of these documents. She had the evidence. And whether DCF felt something was different or back to one another didn't matter to her. What mattered was that she had the evidence. She wasn't reopening the evidence. The only thing she was doing was to open that to the limited purpose of determining when DCF made the change and decided to back the cousins. Was there something new that DCF suddenly discovered? I think the examples she used were, for example, is there suddenly a drug issue that they need to know about, an addiction, something along those lines? And there wasn't. What came out at the testimony was no. DCF had the same information that had been presented at trial and be presented to the judge. The judge, who was very involved and was aware that there were these two plans right from the start of the trial. And DCF determined that child could make the new bonds and that the V family was kin. And that was it. There was nothing else substantial for the judge to base it on. And therefore, at the closing argument, counsel simply reiterated, as she stated too, as I reiterated at the last closing argument, you have the evidence. And with that evidence, I ask you to do what's in the best interest for the child, which again, to come around full circle, is exactly the standard that this court has, that judge had to review to determine in order to place child. And this court has to determine whether she abused her discretion in that, which is a substantial discretion. And I am suggesting, arguing clearly that she did not. And for that reason, I'm asking you to uphold the decision of the trial court. Thank you.
Thank you very much. Thank you for your argument. We'll turn now to Attorney Kruger for the child.
Good afternoon, Your Honors. May it please the court. Yvette Kruger here on behalf of the child. I would first like to, if I may, briefly address the timing issue that has come up. The APM Stewart's testimony, on which Mother highly relies and describes her as highly qualified, which she was, stated in testimony that the department followed policy, its own regulations, in doing the family find, which is the vast computer-generated family search, which is clearly not a simple endeavor. The adoption social worker sent out, I think, over 40 letters, 49 letters or something to that effect. And she did it fairly soon, within a month and a half or so, in early March, that was done in 2019. She was appointed February 19th, but in any event, APM Stewart testified that the family find was done according to DCF policy or regulations, which means after. Mother's attorney focuses the argument on kin and that a search for kin should have been done essentially at the 6-week mark when everyone thought that this would go to termination, but that's not the department's regulations. Secondly, as far as kin, the biological connection, I would say that the child actually has, and I believe the judge found in many findings, the child has greater opportunity for connection to the biological family, biological parents in particular, and family with the foster parents. Findings 133 and 134 make that very clear, that the foster parents are familiar with the biological parents and that the foster parents value the biological connections and would prioritize a relationship with the biological parents and family. Notably, there's no such finding regarding the V's. In addition, on page 12 of the policy document that Mother cites in her brief, it states that the department encourages parents to identify, this is in the initial stages, the parents to identify potential placements that are child specific, such as relatives, friends, teachers. It's notable that the V's were not identified by anyone, not the maternal grandmother, not the parents, not the mother. Mrs. V testified and Mr. V testified that they had no contact with maternal grandmother prior to 2008 when they sent her a wedding invitation, and prior to that she had no contact. The last time was she saw mother when mother was a child, and Mrs. V at trial was 56 years old. So the tremendous emphasis on family and that this child should be with family, the judge didn't buy in finding 111 when she found that the V's believe that the child should be with family, but they don't know the biological parents, and they can only provide family history about the maternal grandparents. In addition to what my brother counsel talked about, there's also the geographical proximity. The paternal grandparents were in contact with her for visits. Foster mother met with mother, and she has a track record of, and the adoption worker also testified, the sites are in my brief, of how strongly foster parents feel about maintaining the connection to the biological parents and family. That adoption doesn't mean less family, it means more family.
Can I ask you one question? How recently have you spoken with or seen, whether by Zoom or otherwise, your client?
Well, my client is now 2.5. I saw him a couple of months ago, and I spoke with the foster mother today.
But not with the child?
No.
He's 2.5, so I don't know what you would talk about.
Barely, yeah.
And is the child still in this placement? There's been no disruption post-trial?
No, he's
still in the placement.
He's still in the placement. Yes, he is. I would just add, Your Honors, that the findings show that the judge fully considered and properly balanced the child's interests in his strong family bonds with his foster family and stability with the only family that he knows, with his interest in his connection to his biological family, which is more strongly supported by the foster family, and the potential trauma to him, which was found in, addressed in finding 112, which the V's do not appreciate because they also, and I think it's made worse by the fact that the V's do not appreciate the strong bond that the child has to his foster family. The judge, specifically states that the V's do not acknowledge or appreciate the potential trauma to a child, any child, from being removed from the only family he knows and loves. I think that's a reasonable inference to be made without any expert testimony. If your honors have any questions, I would just ask that the judge's decision, placement decision, be affirmed.
You know, I see no questions. These cases are always very difficult. I'm sure it was difficult for the trial judge. It's going to be difficult for us, but we're going to take the case under advisement and get an answer back to you as soon as possible. It's still the month of January, and on behalf of the panel, we'd like to wish all of you a very safe and very healthy new year, and not just for the month of January, but for the entire year. Thank you all for your arguments, and we'll take the case under advisement.